On the civil law, that's Indiana. One of the sale that happened in there, that or. Place your focus. I'll bring all that. And she probably want to make sure it got off, so we need to. I'm about to go out there.
Got a bridge crowd. Last weekend, this afternoon. Damage. That was. All I got this afternoon is, Rick Spears and Dish Ron. I talked to Ted, and he's going to appear remotely and get, things. Looking to Emily, get on, and.
Yeah.
From today, and at least that's good. And try to get out here as quick as I can, and I think I've got jail here at Gabbard, and some of these life things. We don't have character solved with what.
Yeah, Garrett's.
Yeah, we know what we're doing, we just don't. We don't. Because they can bring it last week. Okay.
The thing is, the paper. Got it. I don't know if that's a blue flag. I don't know. I never come in and out. I'll take that. So.
Okay, so it's an official. Yeah.
I always forget. Downstairs. Get a blanket for you, that's but if we already have. Jessica, I will not, but I will.
I'll touch it.
All rise, circuit court, thank you, we preside.
Please bow your head for a moment of silence in recognition of loss of Russell County benefits. Thank you very much. Commonwealth versus, I guess we have a transaction. Right here yet? David Hammer.
Well, if they start now, this is.
Morning. It's Commonwealth versus David Hammer. Are you David Hammer?
Yes, sir.
You born in 1987?
Yes, sir.
What's the last four digits to your social security number?
2512.
You're here on a probation revocation. Office of Public Advocacy Representation. What do you have, Mr. Stockton?
Well, this is the one we attempted to have a hearing on last time, Your Honor, and I guess we need to go ahead and have it.
Okay.
Yeah.
Call
Officer Dyer.
Officer Dyer, will you raise your right hand? Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Okay, proceed.
Officer Dyer, can you tell the court when you started taking over and supervising Mr. Hammer?
I started supervising him in March.
Okay. And prior to that, had he been in rehab?
Yes.
Okay. And did he complete that rehab and where was it?
No,
Okay, and was that the Phoenix project?
it was.
Okay, and did he leave on February 26, 2024?
Yes.
Okay, and when did he report to you, or did he ever report to you?
He reported to me in March, about March 5th or 6th,
Okay,
early March.
and did he have another report date after that?
Yes.
And did he comply?
I mean, he eventually started showing up. Yes.
Okay.
Not originally,
What-
but
What problems or violations did he have after March?
what violations he had since March?
Yes.
Okay. Well, he failed to complete treatment. He
Okay,
switched from the Phoenix project and was being seen at Bluegrass Professional Counseling. And I have a letter from them that said he was referred by the Phoenix project and he was last seen by Bluegrass Professional Counseling on March 27th. And he is no longer allowed to attend Bluegrass Professional Counseling in Munfordville in the future due to inappropriate behavior.
okay. And subsequent to that, subsequent to the time he was released from Bluegrass, did he have any criminal violations, any criminal
Yes.
charges? Okay, and
Yeah.
what were they?
He had a new misdemeanor arrest for shoplifting in Hardin County and a theft by unlawful taking or receiving stolen property charge in Hart County.
Okay, was he convicted of the case in Hardin County on the shoplifting at Walmart?
Yes.
And what date was that conviction?
That date was convicted. It's pretty recent. Let's see. I'm trying to find it for you here, sir. I believe it was in May, but I'm not 100% sure. It was in the last couple months.
Let's see. Your report says on August 5th, 2024.
Yes, sir. Trying to find that report. But yes, that would be correct. Whatever is in the report is the correct date.
I have no further questions, Judge.
Any questions?
Just briefly, Your Honor. Ryan Roby here. I represent Mr. Hammer. Mr. Hammer was in a sober living house on his own volition. Isn't that right?
Which in the Phoenix project,
Yes.
he failed a drug screen and he was recommended by the SSC to go to the Phoenix project.
Was he court ordered to complete it?
I believe it was recommended by the SSC in his violation report. Typically, they say to follow all recommendations by the SSC.
Talking about Mr. Hammer in particular, do you have any idea if he was ever court ordered to
It
complete
doesn't
it?
matter. He answered the question. If he's in, move on.
Fair enough. Do you remember having a conversation with Mr. Hammer about him having to leave this sober living to enroll in college?
I believe in the contact notes, it says that he was enrolling in college and he had left the Phoenix project because they didn't want him in college classes.
And are you tracking Mr. Hammer's other cases in Hart and Hardin?
His Hardin County case has been closed. He's been convicted in that one. The Hart County case has been continued out.
And are you aware that the judge in Hart County has allowed him to go to rehab there?
Yes.
Nothing further, Judge.
I don't have anything further.
Any other witnesses?
I do not.
Do you have any witnesses you'd like to call?
No witnesses, Judge.
Okay. You have an argument?
Argument, Judge. Judge, Mr. Hammer's been in custody over 90 days since this infraction. The infractions are both theft charges. We all know theft goes hand in hand with addiction. Mr. Hammer is asking this court to allow him what the Judge Miller in Hart County has ordered him on a bond to be released to rehab if this court would allow it.
Is it Judge Miller, a district judge?
Yes, yes. It's a misdemeanor case. He has that set up, Judge. He wants to get better. He's asking the court to sanction him, to give him time served on the sanction and to release him to rehab.
Mr. Stockton, what do you have to say?
Well, the difficulty the Commonwealth has with that is he was in rehab at the Phoenix Project. He left. He was discharged from Bluegrass. That's 2 rehabs since February. And then he had a shoplifting case at Walmart for $189 where he stole 6 plants and pulled up and took them. And, you know, people may think, well, that's all right, steal from Walmart. But every time I go to Walmart or anybody else goes to Walmart, everything's high because people are stealing from it. And so I don't know why anybody thinks they should just keep getting to go to rehab and rehab when they're violating the law.
Yeah, I'm going to revoke Mr. Hammer. He can serve out and finish his, and get on parole. We'll let you on parole, and then you won't, I don't think that we're in a situation where we can supervise him under probation or have him in rehab. He's not going to comply. I hope during the time you're incarcerated, you'll take advantage of the programs there. You turn yourself around. Thank you very much.
Thank you, Judge.
Daniel Howard, sentencing. Daniel Howard, sentencing.
Believe there's.
Megan, if you're listening, like I need precincts investigation. You can step back there and see if she got precincts investigation. Wow. Usually separate.
So I don't know who first.
You have your copy of the precincts investigation.
Not our copy, but we did review it with him.
You have a copy of it.
I should have.
Our printer is torn. I'll give it back to you to send it. Thank you very much. Terry, have you had an opportunity to review the precincts investigation for probation parole?
He's asking you if you gone over it.
Yes, sir. Congratulations, gentlemen. should not be sentenced.
Okay. No further.
Is this a probated sentence?
Yes, Your Honor. Mr. Howard owes child support. He lives in Florida. And this is the case. We entered the plea of the arraignment, so he wouldn't have to stay but 30 days in jail. He just needs to understand if he's probated, he's got to meet with probation and parole and get clearance before he goes back to Florida. Yes, sir.
And the $500 payment was made on Tuesday this week.
Yes, sir, he was, yes.
When pleaded guilty of flagrant unsupported, he should receive a sentence of 5 years, probated for 5 years. Probation shall continue until his child support arrears are paid in full. Probation be supervised. Okay. And that was the probation officer, the probation parole officer. When can he meet with the probation parole?
You need to be this evening, Your Honor.
What's this evening, this afternoon, you mean?
1, 2 o'clock, be fine.
And you'll go back to the Dare County Jail. You can go out to Dare County Jail and be released and have somebody take you to probation parole.
Yeah, my own girlfriend's up here from Florida.
Well, hope she had a nice trip. Have a better trip back. Hopefully you get, when she picks you up at the Dare County Jail, she'll take you over to probation parole office. You check it and fill forms out. Sit back there and talk to you right now. Okay. $185 is what your court cost you. So you need some time to pay that.
Yes, sir.
Okay, you start paying it $30 a month in addition to your probation, to your child support. Okay.
Thank you, Judge.
Jeremy Jones is next. Or is it? Good morning. Are you Jeremy Jones? Yes, sir. Okay, you born in 1986? Yes. Last 4 digits, social security number 8459? Yes. You're here today for sentencing. Have you had an opportunity to look at pre-sentence investigation before doing a probation parole? Yes. Is it substantially correct? Yes, sir. Your reason shown you should not be sentenced.
No, Your Honor.
Well, plead guilty possession of firearm by conviction felon defendant shall receive a sentence of 1 year served. Stipulated revocation of 18 CR 0077 and 19 CR 0084. 1 year sentence in 21 CR 87. It's to run consecutively to 6 year sentence in 18 CR 0077 and 19 CR 0084. Okay. Thank you very much.
Thank you, Judge.
I'm gonna wait your court call since you're gonna serve the town. Okay, thanks for being here. Okay, I've got Thomas O'Donnell here, but I don't believe there's any reason or counsel, Mr. O'Donnell present.
Your Honor, Ms. Durford had, I'm here, but Ms. Durford had contacted Megan today. She thought this would have to be done at the end of the docket, given the nature of
It will
it.
be, that's what I was gonna say.
So she's on her way she had Marion Circuit this morning.
Okay, so we'll get back there and go to April Osborne. Cromwell versus April Osborne. 19 CR 0043 for sentencing, and 24 CR 0058 for review. What is review, Mr. Stock?
I believe, Your Honor, that's because one of these cases is a misdemeanor. 24 CR is revoked, 19 CR 43 is a misdemeanor. They're both on percentage.
She's not having her even.
Okay.
Okay, I didn't know that.
Mr. Bailey gets the UI forms there first. Have you filled in yet? Filled in. That's your DUI form to acknowledge the fact that you realize that those DUIs would be enhanced. Was that a DUI first?
It's.
Okay. You retrieved that? Give it to the clerk. You had an opportunity to look at the pre-sentence investigation report done on probation parole.
Yes, sir.
Counsel, it's essentially correct.
It is, Judge.
The diversion was voided on August 29th. So you had 3 years, pre-trial diverted for 5 years, so I'll send you to 3 years and give you credit for time served.
Okay. Judge, on Ms. Osborne's, I'd ask the court consider, we have a bed letter to tender for ARC.
You have a what?
A bed letter to tender for ARC if the court will consider.
Well, the problem is she's outside of my control. You know, she's with the Department of Corrections.
Yeah, she was on a misdemeanor probation, Judge, and then she got the new felony case. If they want to do that at shock, I'd be agreeable to it.
We'll take a look at that at shock, early shock probation.
Address it, shock, Judge.
Yeah.
Thank you.
William Rowe. Mr. Rowe, get behind this podium over here. Good morning. Good morning. This is Commonwealth of Kentucky versus William Rowe, 23 CR 0022. You're represented by Office of Public Advocacy. Have you had an opportunity to look at since investigation report of a probation parole? Have you?
The PSI?
Yeah.
Yes, sir.
Okay, is it substantially correct?
Yes.
Okay, is there any reason why the-
Judge.
Yes.
He required a sexual offender evaluation for this charge, and one has not been completed yet.
That's probably not, I didn't know in class D you had to do that, so we didn't know.
And we'll just have to put it off then. Can you advance this, can you tell them to advance that report pretty quickly?
I can try, Your Honor.
You can tell them that.
I can tell them that.
I can see why there's a backlog now, because only one person in the state doing this, they're doing some big felonies on that, I can see why there's a backlog.
We'll have to pass over this thing. Okay, understood. They'll be able to interview you soon. Okay.
Yes, sir.
Here you go. I'm gonna try to get next month. I'll personally give us the address of the person, tell them that it was overlooked and he's already been here for one appearance for sentencing. We'd appreciate if they advance. Yeah, okay. Thank you very much.
Thank you. What will that next date be, Judge?
The next date will be October the 24th.
Thank you.
Counsel for Thomas O'Donnell come up, please. Could you put me on this conference? See, they're gonna have to stay here all day with him now. Oh, she's not here. Because they're finished. This is everybody that transport. This is just an exploitative motion. You know, so I don't know when you want to go back and tell him there's no reason for him to have to stay down here in this little crap jail, see if he'll waive his presence at the ex parte motion. And it's for an out-of-state expert neuro, some kind of person. It's the only one in the world who's Washington D.C. Okay, so see what he said. He waives that where's the president? I'll come out and bring him out, but where the president's gonna be on his way back, you know, he doesn't want to sit back there for 4 or 5 hours.
Okay.
Okay. She needs to talk to Mr. O'Connell for a second, okay? Take that off. Okay, Brockman Carter. Monroe Circuit Court case, Brockman Carter. Is he back, is he incarcerated here? Where is Brockman? He's Monroe County, Monroe County case. Mr. Bell?
Yes, sir,
You've got Brockman Carter on here. Did you have him transported?
You're not good.
Well, it's hard, had to have a hard to have a hearing without him transported.
Some reason I thought they done it by Zoom like they do in Monroe and other places. I apologize. I mean, I hate it for him.
Well, what you might do.
Judge,
Yes.
the Commonwealth has filed a motion to continue this hearing.
Well, I wanted to tell the court if it's necessary, but I can proceed. Trenton Tooley's out of state today, but Lucas Gerald's is here that was there, one of the arresting officers. And I got Deputy Richardson here on the home incarceration, so I could proceed if there wasn't no objection.
Well, let's see if we can get a hold of Barron County. You know anybody at Barron County Jail?
Yes, sir, a few people.
Okay, you also have Christopher Stillwell.
I've got him here, Judge.
Let's do Christopher Stillwell, and then you can call and see if Barron County can be here, and we'll put y'all up front so you won't have to sit here all day. Okay, Christopher Stillwell, Monroe Circuit Court. Commonwealth versus Christopher Stillwell, 24 CR 0012. You are Christopher Stillwell.
We got a felony plea, Your Honor.
Are you Christopher Stillwell?
Yes, sir.
Okay, were you born in 1975?
Yes, sir.
Last 4 digits of social security number 6497.
Yes, sir.
Motion been filed that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that was just identified in 24 CR 0012?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice? Are you impaired in any way today?
No, sir.
Okay. Have you viewed the evidence the Commonwealth has against you? Are you fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky United States Constitution. Before I can accept your plea, I need to know that you understand those rights.
Yes.
I'm going to go over them at the end. I'm going to ask you to understand, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, your right to be represented by counsel, jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove out reasonable doubt that you're guilty of the charge against you. You understand it, but hearing a plea that you give up all those rights. You understand that?
Yes, sir.
Now, I consider the Commonwealth's recommendation, but I may apply your range of sentence provided law. I don't have to accept the recommendation. In the event that I look at the pre-sentence investigation and decline to agree with that, I decide to impose a harsher sentence. You have a right to withdraw your plea, proceed to trial. You understand that, Mr. Stockton? What is the Commonwealth's recommendation?
Your Honor, Mr. Stillwell plead guilty to trafficking over 2 grams of methamphetamine. You'll have a 10-year sentence, serve 180 days home incarceration, pay a $2,000 fine, and the balance be prorated for 5 years. He'll receive credit for time served, if any. All evidence in this case will be forfeited and destroyed, and he will pay court costs at the discretion of the court.
Is that your understanding? We know what the court cost over there is. Okay. What is it, what would the court cost here? I'm gonna say $200 court cost. You need some time to pay that?
Yes, sir.
You pay it $50 a month, first payment, you get that 30 days. Are you pleading guilty because you did commit the act charged in the indictment?
Yes, sir.
You of your own free will?
Yes, sir.
Okay, knowing your constitutional rights extends to your desire to proceed without a court to fix your punishment.
Yes.
Did you understand that by entering pleading guilty to any future convictions could be enhanced? Is that your signature on the document?
Yes.
What's the next rule in Monroe County? What? October eighth.
Yeah.
So you'll be,
Judge, I won't be here October the eighth.
well, we're not gonna be here either. We're gonna be in Monroe County.
I won't be in Monroe County. I won't be in the state of Kentucky.
Well, you have somebody standing in for you?
I don't have nobody standing there. Kind of a lone wolf in that regard.
You know, I just don't, I hate not to have him supervise me. Yeah, I think, you know,
I mean, Judge, we don't care to move forward today if it.
we can't waive the precinct's investigation. Let me see, we'll figure out something, you know, I mean. Where are you on the third? We have a Monroe County trial scheduled for the third. Marley, it's gonna go. Is that correct?
don't see a reason.
Can you be over there on the third for sentencing?
What time, Judge?
9 a.m. Got a trial starting at 9 a.m.
I gotta, yeah, I mean,
You can come later today if you want to.
if I could come, I got a sentencing in Edmonds County. If I could come about 1 o'clock, Judge.
That'd be fine.
Okay.
Okay, and you'll need to meet with the probation parole officer right there. You can give him the information.
Judge, you also said you're paying $50 a month on the court costs. He'll need to pay the fine in some manner too. I don't know. It's a $2,000 fine.
How much?
$2,000. So
He is in the process right now. He's working for a tree company right now, but he went back to school to get his CDLs. He hopes to finish up with that in 3 weeks, and I think he'll be making a lot more money when he gets his CDL and stuff.
Well, let's let him pay a total of $100 a month. Okay. Okay, so you'll be over there for sentencing on October the third. At 1 o'clock. You got that down?
Yes, sir.
Okay. You go out and try to get a hold of the Barron County Jail, okay?
Yes, sir, Judge.
Okay. Yes. We'll bring it. All right. Thank you. That's okay. Wait, it doesn't matter how long it takes.
because he's on.
Travis Atkins. I'm one person, Travis Atkins. Are you Travis Atkins?
Yes.
Good morning. Were you born in 1989?
Yes, sir.
Last 4 digits, social security number 8947.
Yes.
You're here for a pretrial conference. What's the Commonwealth have to say?
Diversion, please, Your Honor. Give me.
Mr. Atkins, a motion's been tendered that says you wish to enter plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? This is plea freely and voluntarily given. Are you need to speak up just a little bit.
Yes, sir.
It's a voice activated camera, okay? Are you the same person we just identified in 24 CR 0055?
Yes.
We discussed this matter with your counsel, and are you satisfied with his advice?
Yes, sir.
You reviewed the evidence the Commonwealth has against you, you believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter guilty plea. You have certain rights under Kentucky and United States Constitution require to accept a plea I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial, but you're right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, call testify against you, the right to produce evidence, the right to call witnesses, your paper and process issue. You know, their tendency to right to appeal this matter how to court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charge against you. You understand that by entering a plea of guilty, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided below. I don't have to accept your recommendation. In the event that I don't accept the Commonwealth's recommendation, we decide to impose a harsher sentence. You have the right to withdraw your plea and receive a trial. You understand that?
Yes, sir.
I'm gonna ask you some qualifying questions since I understand that the recommendation will be a pretrial version. Have you been previously diverted in the last 5 years?
Not that I'm aware of.
Well, you would be aware of it. Don't you think?
So, no,
Okay.
sir.
Any felonies in the past 10 years?
No, sir.
Currently on probation.
No, sir.
You understand if you fully complete the diversion program, the charge would be dismissed. Okay, go ahead. What's your recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained, and the defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth, and the defendant shall remain on active supervision until any and all court costs are paid in full and until further request of probation and parole.
Is that what you agreed to?
Yes, sir.
Okay. You understand if you fully complete the diversion program, the charge will be dismissed, pretrial diverted, and the record could be expunged. You have no record. You understand that?
Yes, sir.
If you don't fully complete the diversion program, you brought back before the court, schedule a hearing, and if we say you violate the pretrial diversion and revoke it, you'd be have a pre-sentence investigation for it. Then as soon as you be a convicted felon.
Yes, sir.
That situation is to be used against you in the future. Now, are you understand that?
Yes, sir.
You plead guilty because you did commit the acts charged and be indicted.
Yes.
It's your constitutional rights to explain to you, still use that, simply to plea you guilty and allow the court to fix your punishment. Is that your signature on there?
Yes, sir.
They all agree to accept the pretrial diversion. Okay. And you'll need to meet with the probation and parole officer and get certain information. Court cost is $185. You need some time to pay $185. Okay, you pay $30 a month. Payment $30 for you today, okay?
Your Honor, I have a trial in the last
What do
week.
you say? Raise your right hand and swear that you will be Mr. Carlson.
Your Honor, I have to be in Pulaski Circuit this afternoon for a bench trial. I have one diversion plea and one arraignment remaining on the docket.
Who is it you have?
I have Mark Thomas and I have Maggie Scott.
Let's call Mark Thomas first.
Mark,
Mark Thomas. Commonwealth versus Mark Thomas, 24 CR 0076. Are you Mark Thomas?
Yes, Your Honor.
Born in 1963.
Yes, Your Honor.
Last 4 digits, social security number 435. You're here for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Cumberland County has charged you with possession of controlled substance in the first degree, possession of controlled substance not in the original container. You understand those charges?
Yes, Your Honor.
You acknowledge that your client, Mr. Cross, received indictment, waive formal reading and arraignment, enter plea not guilty or serving all pretrial motions.
yes, Your Honor.
Okay, I am signing a reciprocal discovery order, Mr. Thomas. The Commonwealth will give you information to help you prepare your defense. When is the negotiation date?
October 18th at 9 a.m. here in Cumberland County.
October 18th, 9 a.m. is your negotiation date. Your next court date is October 24th. Both of those are conditions of your bond. Okay.
On the next before.
That's fine.
Okay, who's your other client?
Maggie Scott. Maggie?
Maggie Scott.
Two cases, Your Honor. One transfer complete over here. We're doing the vote.
Commonwealth versus Maggie Scott, 24 CR 0056. You are Maggie Scott, born in 1984. Last four digits, social security number 3307. You have a plea in this case.
Yeah, we have a pretrial diversion, 2 DUI pleas, and there are 2 Cumberland County case numbers.
The Clinton Circuit Court case is 24 CR 00078. Cumberland County case is 24 CR 0076. I understand that you agreed to enter a plea today, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that we just identified in Clinton Circuit Court case 24 CR 0078 and Cumberland Circuit Court case? 24 CR 0056. Same person?
Yes.
Have you had plenty of time to discuss both these cases with your attorney?
Yes, sir.
And you have no objection to the Clinton County case being transferred over here so you can dispose of this evidence? Have you viewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the protect the United States Constitution. I'm gonna go over those rights and end of it. I'm gonna ask you if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speak, trial, but your right to be represented, to be trial, right to fight Fox down all. Which all testify against you, right to produce evidence, right to call witnesses, your favorite right to fill this matter, higher court to lose. Right to part of the Commonwealth, prove on the reasonable doubt that you're guilty charged against you. Understand that making you guilty plea, they can give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I'm applying range of sentence provided by law. I don't have to accept the recommendation. Even if I do not accept the recommendation to decide the post-partial sentence, you have a right to withdraw your plea, go to trial. Now, this is your recommendation. Go ahead with your recommendation.
Okay, upon a plea of guilty to possession of a controlled substance, first degree methamphetamine in case number 24 CR 56, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances, first offense in case number 24 CR 56, the defendant shall pay a fine of $200 plus court costs. Upon a plea of guilty to possession of a controlled substance, first degree, 2 counts in case number 24 CR 78, the defendant shall receive a sentence of 2.5 years on each charge to run concurrently for a total of 2.5 years. Upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances, first offense in case number 24 CR 78, the defendant shall pay a fine of $200 plus court costs. The sentences in case number 24 CR 56 and 24 CR 78 are to run consecutively for a total of 5 years. Pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall pay fines and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky and shall remain on active supervision until any and all fines, court costs are paid in full and until further requested probation and parole.
Now, you understand if you successfully complete the diversion programs, charge, the felony charge will be dismissed. You understand that? You also understand if you enter this plea, the DUIs, and both the DUIs are enhanced. You get some severe penalties. You got 2 separate DUIs here.
Yes, sir.
And they're enhanceable. You understand that? Is this what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment? Are you doing so for your own free will? Knowing your constitutional rights is still your desire to proceed with these pleas and allow the court to fix your punishment. That's your signature on the motion to enter a plea and on the version. Now, Mr. Stockton, was there any reason why she didn't look at drug court on?
I looked at drug court, and according to Mr. Krause, she's working a lot, has custody of children and doesn't have much help, but I will tell her if she makes a Bible, as Mr. Krause said, that's probably where she's headed. She had any positive drug tests.
we're probably better off for you to do the drug court now. But, you know, you've made a disagreement with the Commonwealth, and Commonwealth is giving you a starter warning. I don't know if you violate whether I'll agree to the drug court or not.
Yeah.
So I mean, they're giving you an opportunity. You've got these obligations with these children, the Commonwealth taking that in consideration. So it's, my old law professor used to say one time, you need to live at the foot of the cross. You know what I mean? Like the probate, what is the total court cost?
Total for both of them?
Yes.
So the $1,435.
Okay, $1,435. Now, I'm gonna waive the court costs in Clinton County. Okay, I'm gonna waive the Clinton County since we merged it over here and you can pay it here. Can you pay $50 a month? If you can't, tell me.
Yeah.
Okay, $50 a month, the first payment's due 30 days from today, okay? You need to meet the probation parole officer.
Your Honor, other than one case on the
You
jail
said you
docket,
had two,
well,
done two.
we're having to get another date on it because we had a plea and it's not
What
going
is
to
it?
work, so.
Gary, we were going to do a plea, and we found out he's a state prisoner, so we'll have to go back to the drawing board. We'll just put him back for next month and the negotiation date probably.
Is he free?
No, he's in the Dare County jail.
I'm moving there, yeah, docket.
Thank you for taking me up.
Yeah.
Anthony Barker. Commonwealth versus Anthony Barker, 24 CR 0059. Good morning, Mr. Barker. Born in 1973. Last four digits, social security number 6193. You know, a pre-trial conference, what's the Commonwealth have to say?
Your Honor, we have another pretrial and negotiation day. We do not have a lab yet in this case.
Will October be too soon, do you think?
Well, let's set it for the October dates, and if we don't have the lab, I can excuse Mr. Barger from the negotiation.
October the 18th and October 24th, 9 a.m., both here are conditions of your bond, okay?
Thank you, Judge.
Yeah. Ramona Bird. Ramona Bird. Are you Ramona Bird?
Yes.
Good morning.
Good morning.
You're on 24 CR 0046. For a pre-trial conference, were you born in 1969, Ms. Bird?
Yes.
Last four digits, social security number 9222.
Yes.
You're represented by Mr. Poindexter. What do you have to say?
Your Honor, Miss Bird is also a co-defendant with Jason Hooks. Mr. Poindexter was not able to be here last month, so I'd like to set Mr. Hooks and Miss Bird for the October date along with the negotiation date to see if we can resolve it. If not, we can get a trial date.
Jason Hooks, are you here? Please come forward also. You represent both? You represent both, please?
No, sir.
No, Mr. Pennington represents Mr. Hooks. No, it's the
Public advocate, represent Mr. Hooks. Where is the public advocate? Are you Jason Hooks? Yes, sir. Born in 1973. Is that right? Last four digits. Y'all move over this way and let Mr. Hooks. Mr. Hooks, last four digits of your social security number is 7669.
yes, sir.
You're a co-defendant with Ramona Bird, Mr. Hooks, and what does the Commonwealth have to say? You're gonna have October 18th for negotiations
Yes.
and October 24th for your next conference date here. Both of those are conditions of your bond. Both of you understand that?
Say October 18th for negotiation.
October 18th at 9 a.m. And then the next court date is October the 24th. Okay?
Thank you, Judge.
Thank you. Sarah Black. Commonwealth versus Sarah Black, 24 CR 0043. Are you Sarah Black? You're represented by Office of Public Advocacy.
Yes.
You're born in 1977.
Yes.
Last 4 digits, social security number 0901.
Yes, sir.
You're in 24 CR 0043. What does the Commonwealth have to say about this case?
It's a reversion plea, Your Honor.
May I approach good?
Just hold it there. I'll let her identify her. Ma'am, a motion has been filed, says you wish to enter guilty. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea free to involuntary given?
Yes.
You previously stated your name, social security number, you're the same person, that 24 CR 0043. Is that correct?
Yes, sir.
Is your judgment impaired today?
No.
Okay, we can discuss this matter with your attorney and you're satisfied with this advice. Do the evidence the Commonwealth has against you, feel like you're fully informed about the case?
Yes.
You understand that you do not have to enter guilty plea today. You have certain rights under Kentucky and United States Constitution. I need to know that you fully understand those rights.
Yeah.
You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. The right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. The right to use evidence. Right to call witnesses in favor. Right to bill this matter higher political beliefs. Right to apply the Commonwealth prove beyond a reasonable doubt that you guilty of charge against your understanding.
Yeah.
That by entering a guilty plea today, you give up all those rights. You understand that?
Yeah.
Now, I may consider the Commonwealth's recommendation, but I may apply any sentence allowed by law. I don't have to accept the recommendation. Usually, if I don't accept the recommendation, you can withdraw your plea and proceed to a trial. Now, what is our Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall pay fine and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Like, I want to ask you a few questions, see if you qualify. You've previously been diverted in the last 5 years.
Beg your pardon?
Have you previously been pre-trial diverted in the last 5 years?
No, sir.
Any felons in the past 10 years?
Not any.
Do what?
I haven't had any felonies.
Okay. Are you currently on probation?
No.
Okay. You understand if you successfully complete diversion program, the charges will be dismissed, pre-trial diverted, and you can have your record expunged. You understand that?
Sir.
And you understand that if you do not complete successfully pre-trial diversion, be brought back and forth to court for a hearing, and if I find that you violate the terms, I revoke it. You can have a pre-sentence investigation for it. And you'll be a convicted felon that can be used against you in the future on any felony charges in Kentucky. You understand that?
Yes, sir.
Has anyone, including your attorney, offered you any benefit for learning this plea?
Beg your pardon?
Has anyone offered you any extra benefit, or are you just
No.
entering a plea because you did commit the acts?
No.
You understand that, are you doing this of your own free will?
Yes, sir.
Knowing your constitutional rights, that explain to me it's still your desire to proceed and enter this plea and allow the court to fix your punishment. Is that your signature on there?
Yes, sir.
Okay. I'll accept the plea agreement and sign the diversion order. What are the total court costs? She had a $500 fee for insurance. $725. $725. You need some time to pay that.
Yes, sir.
Or can you pay it at $50 a month?
Yes.
The first payment will be done in 30 days. $50 to get it paid. You don't need to meet the probation and parole officer there to give information.
Okay.
Okay?
Thank you.
Thank you, Judge.
Your Honor, can you call Commonwealth versus Kenneth Pulliam next? It's on the live docket. I'm getting ready to lose one of my witnesses if we don't hear.
Commonwealth versus Kenneth Pulliam. Did Mr. Bell get hold of the Marion County Jail?
There it is.
Hey, Judge, they told me they were having him on 10 o'clock.
He's on.
He's on now. We'll do him next then, okay? Commonwealth versus Kenneth Pulliam, 22 CR 0089. Are you Kenneth Pulliam?
Yes, sir.
born in 1973. His last 4 digits, social security number 3449. You're on probation or vacation. What does it come with? Have to say, just tell me what the charges are first.
Your Honor, he has 3 years sentence on DUI 4. If he served 120 days like he was supposed to. And then of February 29th of 2024, he got arrested and got a slew of charges, including operating with no interlock device, failure to surrender operator's license, fictitious license. And that's the reason I've got the state police.
You want to stipulate to that?
No.
Okay. Okay, who's the
The
witness?
Trooper Phillips and Trooper Walters, they're both on.
Have y'all raised your right hand, troopers? I see one trooper there, Phillips.
Trooper Walters, Tyler Watt. I see your name, but I don't see him turn his camera.
I'm trying to turn my camera on now.
Baker, are you involved in this case? Baker's involved in it too.
Yeah, that may be right. Yes, Michelle Baker's also involved.
Michelle Baker, okay, y'all, all three raise your right hand, you swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do.
Oh, you're
I do.
Which one you gonna call first?
Call Trooper Phillips, Your Honor.
Bill.
Would you state your name, please?
Trooper Hayden Phillips.
Trooper Phillips, what jurisdiction do you usually patrol?
The Barrenhart and Edmondson area of Kentucky State Police Post 3 at Bowling Green.
Okay. I want to ask you about an incident that occurred in February of this year involving Kenneth Pulliam. Do you recall that?
Yes, sir, I do.
And what date was that?
It was. Give me just a second. I'll be able to tell you. (6/29 of 2024).
Okay, and you tell the court what happened, the reason you engaged with Mr. Pulliam.
Yes, sir. Trooper Walters and I driving on Keno Road in the Barron County community. Upon the initial observation, Trooper Walters had attempted to perform a registration check through NCIC, but there was no vehicle found under that plate number at that time. Trooper Walters and I observed the vehicle pull into a driveway and turn its headlights off. At that time, we had turned around and observed the operator exiting the vehicle by the roadway. At that time, we made contact with the male operator. He was identified as Kenneth Pulliam. It was found that the vehicle was title only and that the operator had no insurance or valid registration. It was also found that the operator had produced a fictitious operator's license that was suspended. That was confirmed through Bowling Green Post. And the suspended license was restricted to an interlock device, although the vehicle that he was operating at the time had no interlock device installed in it.
Okay. Now, this is something I wanted to clarify with you. He produced a driver's license, is that correct?
That is correct.
Now, you say it's fictitious. Why are you saying it's fictitious?
When they're suspended, they're to do surrendered to the courts, and if not, then if they produce that after they're suspended, then it's a fictitious operator's license.
Okay. Okay. And he was eligible for a license with an interlock device, but did he produce that?
No, sir, he did not.
Okay. And there was no interlock device on the vehicle?
There was not.
Okay. Did he make any statements or anything about his license at the time to you when he was stopped?
I don't recall exactly what he had said.
Okay. I don't have any other questions for this witness.
You want to inquire?
Trooper Ryan Roby here on behalf of the defendant. Whenever you stopped him and asked him for his ID, he did not hand you that driver's license, correct?
I would have to go back and see if he handed it to me at that time or not. I don't have my camera footage in front of me.
Okay. Do you recall that after you searched him, you got his billfold and you found it in his wallet at that point? Does that ring a bell?
I'd have to go back and review the video.
Okay, so as you testify here today, you don't remember what happened?
That's correct.
The license he had in his billfold, that was his actual state issued driver's license, correct?
That's correct.
Not one that he printed or made up himself.
That's correct.
Do you have any certified records from the Department of Transportation saying that he should have had an ignition interlock device in his vehicle?
Through the NCIC, which is the national database, it stated that he was restricted to an interlock.
In your experience, those things can be incorrect, right?
That would be between the courts and the national database.
As you're testifying here today, do you have any documentation?
I do not have documentation that it said restricted to an interlock.
Nothing further, Judge.
You have another witness. Can this witness be?
He can be excused, yeah.
Trooper, you can be excused. Call your next witness.
I call Trooper Walters, I'm sorry.
Well,
Yes, sir.
why?
Yeah, Trooper Walters, you just heard Trooper Phillips testify. Do you have any different recollection on any of this?
No, sir, not that I can recall of anything.
Mr. Roby asked a while ago about the driver's license. Do you remember how that was retrieved?
To the best of my knowledge, I just recall speaking with Mr. Pullen, and he first stated, I believe, that he did not have a driver's license or an ID on him. And I believe that it was later, once he was under arrest and we were searching his persons, is whenever we located the ID in his wallet.
So when you asked him to produce a valid driver's license, he could not.
That's correct. To the best I can recall.
Okay. I have nothing further, Your Honor.
You have any questions, Mr. Trooper?
No, Judge.
You may be released. Now you're third witness.
Call Miss Baker.
Officer Baker, you've been previously sworn. You may inquire.
Miss Baker, how long have you been supervising Mr. Pulliam?
I took over his supervision in April of 2023.
Okay. Has he had any violations during that time?
Other than, I believe the only other supervision violation he has is he had a positive drug test for marijuana.
Okay, and that'd been in February 29th of this year.
That is correct, sir.
Now, are you aware of his driver's license situation?
To the best of my knowledge, I was under the impression the entire time I've been supervising him that he has had a suspended driver's license. He has reported to me that it was a mistake with the DMV, but I told him that is between him and the DMV and that he needs to get it corrected before he's allowed to operate a vehicle. He knows he's not allowed to drive.
Okay, nothing further.
You want to apply?
No, Judge.
You may be really, you may be.
I have no other witness.
You want to make your statement?
Yeah. Your Honor, all we know is in this case is that Mr. Pulliam was operating a vehicle. He's had a DUI fourth. He had a couple in a 2-year period, and he's not allowed to drive a vehicle. Thankfully, he wasn't impaired or anything. But if he's eligible for an interlock device, he should have it. He needs to comply with the law just like anybody else, especially after you've had that many DUIs.
Judge, on behalf of Mr. Pulliam, Mr. Stockton says we know he's not allowed to drive a vehicle. I don't know that. The officers didn't produce any evidence to that effect. Probation officer said it was her
He's
impression.
with you today. You want him to produce a valid driver's license.
I don't believe he can get one right now, Judge.
But then he doesn't, he's driving without one, right?
Well, I think that would shift the burden to the defendant. It's Commonwealth's motion.
And they say he doesn't have one.
We've had 3 witnesses say he didn't have one.
There's a difference between being suspended and DUI suspended and requiring ignition interlock device being suspended. I don't believe Mr. Pulliam has a valid driver's license.
That's what he's accused of, is driving without a valid driver's license.
Well, the more serious charges, they've charged him with producing a fictitious driver's license and stuff like that. The one Trooper Walters recalled that.
You can argue that point then. You think that there's not sufficient evidence to move forward on that?
Sure, absolutely. He didn't produce a driver's license first off, and the driver's license he did produce was a state issued driver's license.
Well, they explain that. If you have one that's suspended and presented or have it as fictitious, your argument is he didn't present it. You told him he didn't have it. and then they found it on him.
Correct. He didn't present it, and I don't believe the troopers are correct that if your license is
I wouldn't
suspended,
know because your client wanted to testify.
but my client doesn't know the law.
I'm just asking, he's like cabbaging in and trying to say stuff about it. Maybe you ought to let him testify.
Judge, the issue is he has a pending case in Barron County on this charge. That's still pending, and I'm not his attorney there. I don't feel right having him waive his privilege. Not to testify. Now, it's up to you if you'd like to testify.
Go to your body. Well,
And
I'm
advise
not
him to
gonna force him to testify. He's got a right not to testify.
Judge, what I would ask is that the court let the court system play this out in Barron County, pass him out. He has court in 2 weeks in Barron County. To come next week, to come back and see what happened in Barron County. If all these charges are dismissed or otherwise handled over there, I think that would advise.
Well, I'll just tell you that if he's got a fourth DUI and he's driving without a driver's license, that's enough for me. I'll just tell you that right now. Because having the people who are habitual, people who drive on while intoxicated 4 times, it's a felony. So I'll be glad to put it off, till next month. But I'm gonna tell you that when he comes over here next month, even if those cases are dismissed in some way, he's gonna have to prove to me they've met their burden of proof.
Understood.
Okay? So I will put this off to October 24th, 9 a.m.
Thank you, Judge.
22 CRC. David Collins. Commonwealth versus David Collins, 24 CR 0039. Are you David Collins?
Yep.
Were you born in 1986?
Yeah.
Last 4 years of social security number 6441. You're on 24 CR 0039 for a pre-trial conference. What's the Commonwealth have said?
Your Honor, we need another month to see if the lab report's back.
Okay.
Oh, we got a plea. Oh, I'm sorry, we got a plea on this case. I got confused after last year.
Is it felony plea or diversion?
Diversion.
Mr. Collins, a motion to attend says you wish to enter a plea today. Is that correct?
Yeah.
Are you currently influenced? No. Is this plea freely and voluntarily given?
Yep.
You were previously identified in 24 CR 0039. Is that correct?
Yeah.
Are you the same person that not? Is your judgment prepared today anyway? Discuss this matter with your attorney to be satisfied with his advice.
Yeah.
Review the evidence Commonwealth has against you, believing you're fully informed about the case.
Yeah.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and Massachusetts Constitution. Or I can say, but I need to know that you understand those rights. I'm going to go over them, but at the end of them, I'm going to ask you to understand. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, but jury right to be represented at the counsel at your jury trial. Right to confront and cross-examine all witnesses, call testify against you. Right to use evidence. Right to call witnesses in your favor. Right to pick this matter how court to lose. And the right to require the Commonwealth prove beyond a reason without the guilty charge against you. Understand that by entering a guilty plea, that you give up all those rights. You understand that? But I may consider the Commonwealth's recommendation by may applying range of sentence by the law. I don't have to accept the recommendation. In the event that I do not accept the recommendation, the Commonwealth decide to impose a harsher sentence. You have the right to withdraw your plea. What's the Commonwealth's recommendation?
Upon a plea of guilty to possession of controlled substance, first degree, 2 counts, the defendant shall receive a sentence of 2 1/2 years on each charge to run consecutively for 5 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall receive credit for 55 days. The defendant shall pay a storage fee and tow bill of $650 to the Cumberland County Sheriff's Department for release of a 1999 F-250 pickup truck within 30 days from entry of plea, or will forfeit said truck. The defendant shall pay fines and court costs at the discretion of the court, shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained, and the defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Sir, have you finished been diverted in the last 5 years? Have you failed in conviction in the last 10 years? Are you currently on probation? Okay. And you understand if you successfully complete the diversion program, the case will be dismissed pre-trial. The verdict will have your record expunged, but if you do not complete this, successfully complete the diversion program, or if you're brought back in front of that court, I can void your pre-trial diversion or a pre-sentence investigation, what will be a convicted felon, make a arrest against you in the future. You understand that?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yep.
Okay, you do so of your own free will. Knowing your constitutional rights, still you desire to proceed by the court to fix your punishment within the range permitted by law. Is that your signature on the diversion agreement and on the motion in or plea?
Yep.
Accept those, Mr. Bailey. I'm gonna pick them up, give the card. What's the quote? You had 650 feet, $650 for
Totals $897.
$897.50. Okay, can you pay that at $50 a month?
He's already paid the $650, Your Honor.
Can we back that up? What?
$250.
$215, you can pay that $30 a month, starting 30 days from today, okay? They need to be a probation parole officer. Okay, now I'm gonna go over and take some of these people that we have waiting online.
I didn't know if he was gonna get Mr. Carter or not. Oh, no, Mr. Carter, Barron County.
Yeah, that's where I'm going.
Okay.
Barron County Jail. Then we'll do Hopkins, Russell, and Taylor real quickly. Hopkins, Russell, and Taylor, all our next line. Should be.
Can you hear us, Your Honor?
Yes, it's Barron County.
Yes.
Russell County, we turn your camera off just for a second until we get to the YouTube. Second. Okay. Barron County, will you turn your camera on?
Can you see us? It's saying it's on.
I can now. Commonwealth of Kentucky versus Brockman Carter, Monroe Circuit Court case 24CR0030. You Brockman Carter,
Yes, sir.
born in 1983.
Yes, sir.
4-digit social security number 0829. But what's the Commonwealth? This is a bond reduction and motion to continue, I guess. Johnny Bell.
Judge, this is a revocation on the bond stating that he violated the condition.
Introductions, revocation. Go ahead, the Commonwealth proceed.
Your Honor, I have two witnesses. Deputy Richardson can testify about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 days of when Mr. Carter violated his home incarceration.
Deputy Richardson, you come over here and get in the witness. These boys are jailer over there.
Thank you.
Okay, will you raise your right hand and swear testimony about to get the truth and whole truth?
I do, Your Honor.
Take a seat, speak into the red microphone, state your name and who you
Deputy Ricky Richardson, employed with the Monroe County Sheriff's Office, and I also do the home incarceration program for Monroe County.
proceed.
Deputy Richardson, you also have a business regarding home incarceration.
Yes, R&R Home Monitor.
Okay, has Mr. Carter, Brock Carter, been a client for that business?
He has.
And about how long, you know?
His first initial hookup when he was first arrested was 4/9/24. He was off a few days whenever they had served him with an indictment, and he was still on until September the 10th, 2024.
Okay, what is his parameters as regards to his home incarceration? Where can he go?
He could go to work, medical visits, whenever he's out working, the store. I did give him the option, around close to home, he didn't have nobody to live with himself, I'd let him stop places and get food to eat. And, he was taking care of his grandmother too. And, he would stop and get stuff and take, to help his grandmother out.
Okay, and his work, where was that part of the county was that in?
It was in the Cyclone area. He was doing a lot.
Okay.
And with that, he made several trips back into town to the log yard and.
Go ahead.
And I'm sure fuel and stuff such as
Did
that.
you ever give him permission to go to Summer Shade, Glasgow, or Bowling Green?
No,
Okay. You ever give him permission to go to a liquor store?
no.
Okay. I want to show you the first incident. You can look at that and tell the court what that is.
This was July the 25th, 2024, at approximately 6:54 p.m. The GPS monitor itself will pick up in about a 3-foot radius. And with this one perimeter, it was obvious that he was standing inside the liquor store,
And where was that store located?
Somerset, Kentucky,
Okay. And about what time was that?
6:54 p.m.
Okay. Now, the next, Your Honor, if I can, I'll just make all these accumulative too. The next item I'm gonna show you, August 22nd, 2024.
Just could I have time to find those, please?
I've got a copy.
Okay, good. That'd make it a lot easier on that.
Deputy Richardson, is the highlighted tract, is that the location of the GPS monitor on August 22nd, 2024?
That is correct.
And it looks like Mr. Carter was in Temple Hill,
He was.
Summer Shade,
He was.
Willow Shade, up on, I guess, 163. Did he have permission to be in 88 or Temple Hill?
No, he did.
Okay. I'd like to go ahead.
The one where it's up on the map showing Port 88, it's actually on the Randolph Somerset Road. It's at the golf course
Okay.
in Somerset.
Okay, the next one I want you to look at is August 23rd, 2024. You have that. Yes. Did you tell, according to the GPS monitor, where Mr. Carter was?
Yeah,
I guess my question is, was he in Glasgow?
yeah, he was in Glasgow with Zaxby's Chicken.
Okay. We'll pass that for there.
Is that good?
Next one we'll go to is August 24th, 2024. Swim up there, sorry, I mean, where was Mr. Carter on that day?
He was back at Somerset. That's a service station there. They do have like a deli and stuff there.
Yeah.
The monitor itself never actually went in the liquor store on this particular account.
Okay, was he also out in the Mount Herman area?
And he
Monroe
was,
County?
yeah.
Did he have permission to be there?
No.
Okay. Next one I want you to look at is August 31st, 2024. You tell the court where Mr. Carter was or his ultimate destination that day.
His ultimate destination was Bowling Green.
Okay. Did he have permission to go to Bowling Green?
No.
Where did he go in Bowling Green? Can you tell?
At one point in time, he was around the Western Kentucky University campus. He was just riding around, and then he went to Raising Cane Chicken in Bowling Green before he went home.
Yeah. Next one I want to talk to you about is August 26th, 2024. Did you tell where Mr. Carter was at that?
Well, he went into the cyclone area. He was at, he went to Mount Hermon through Sulphur Lake. At one point in time, he was at, place, Ross and Ross meets on, say, on Third Street. I had told him at that point in time that, I was okay with him stopping, getting his dog food, for he fed his dogs. When he come to town to take care of his grandmother, he would run by there and pick up just a back box of the scrap dog food. He was in Mount Hermon. I mean, I know the resident that he was going to in Mount Hermon, that was one, he went multiple times.
Did he have permission to do that residence?
And,
Okay. And I'll just do one more of these. This one's on, September 6th, 2024. It also appears he was back at Mount Hermon in that same residence. Is that correct?
That's correct.
What's the deal? Whose residence is it? It's not his residence.
It's not his residence.
Whose residence is
Jeremy Carter.
It looks like he was pretty much over the entire northwest part of Monroe County, if I've got my directions correct. Okay. Your Honor, I'd ask that all these exhibits be entered most cumulative exhibit one.
no objection, so ordered.
Now, Deputy Richardson, what happened that led up to Mr. Carter having an arrest warrant issued for him?
On September the 7th, about 12:45 a.m., his battery went dead.
That was a Friday, I believe.
I think it was. Maybe.
Let me see, September 7th was a Saturday.
Saturday.
Okay, what happened then after his battery went dead?
On Monday the 9th, I'd made contact with Mr. Carter, and I told him I'd made several attempts to keep Mr. Carter to keep his monitor charged, and he done fairly good for a little while, and a lot of times he didn't. On this specific occasion, you know, I told him he needed to charge his monitor that was dead and had been for, you know, over a day. He said that he thought his charger was tore up. I had him come to my office there in the Justice Center, and he brought his charger with him. I plugged it up. It started charging just like it's supposed to. While he was sitting there, he was antsy and he was moving around and bouncing it, stepped on the wire 2 or 3 times, and until it finally quit charging. And I gave him another charger at that point in time, a new one, and hooked it back up, made him stay with me for a little while till it charged. And, you know, and at that point in time, he started doing the same thing, bouncing around, and each step, I said, you go fool around if you turn my charger up again, and that's a new one. Yeah. And he finally quit, and, you know, after it charged for a while, he went home.
Okay.
And that was, that morning, whenever I found that's whenever we had talked about the other stuff, and I asked for a warrant. Okay. Because he hadn't come in on the Friday that he's supposed to be in for his negotiation day. And
then his charger is dead most of the week.
He went biggest part of the weekend. I don't have a clue what to do.
Okay. So, and you didn't have any other contact with him after you requested it?
Not until the night that I cut my equipment off, after he was arrested.
After he was arrested?
Yes, sir.
Okay, I don't have any further questions this week.
Thank you, Judge. Deputy Richardson. First, I would like to ask, has during the time that you've been supervising Mr. Carter, has there been any circumstances or situations where he's used any drugs or had any kind of violations as far as drug use or
not to my knowledge,
alcohol use? Nothing like that's been taking place, correct?
Not to my knowledge.
Right.
Yes.
And as far as being cooperative with you, he's been on this since April the 9th of 2024. So that's what, April, May, June, July, about over 5 months. Has he been cooperative with you during that period of time?
Pretty much so. I talked to him about infractions that's going on. I'm sorry, I won't do it again. And, when he's battered would go dead, I'd contact him and, he was Johnny on the spot. He would hook it back up until the next time he let it go dead.
Okay, so I mean, he always came in, cooperated with you, and done what you asked him to do.
Correct.
Now, during these alleged violations, you stated earlier in your testimony that he had permission to work.
He did.
And he worked in the logging business, is that correct?
That's correct.
And with the logging industry, I mean, there's chainsaws to be sharpened, there's oil to be gotten, there's fuel to be gotten.
Yes, to this line of question, Judge, I mean, he testified as his parameters where he was going. Now, if Mr. Carter wants to testify, he need to go, but Deputy Richards already told him he didn't have permission to be there. It doesn't matter what he had to do. I mean, I just don't see the relevance of this.
But he stated that he had the ability to work, Your Honor, and that he had.
Proceed. He made your point.
Thank you, Judge. Let's go back to 7/25/24. You stated that he stopped at a store there in Summershade.
Yes.
As far as stopping in that store, that wouldn't have been anything that would have been a
No.
violation, correct?
That would have been to get fuel. No.
Okay. Now, I've been in that store almost every time that I leave Tompkinsville or Burkesville. I stop there at that Summershade store. You would agree that the liquor store is not any further from this podium to the corner of this desk from where you pay for your groceries and things. Would that be a fair statement?
I would agree with that.
And there's no wall or door or anything in between those two places, correct?
Correct.
And when I was looking at the 7/25 documentation that you give us, may I approach the witness, Your Honor? Could you look at the GPS accuracy that I've circled there on the left bottom corner?
Yes.
And could you state to the court what that number is?
It says GPS accuracy 59 feet.
So you would agree that if he was standing at the place doing what he was supposed to be doing, he was well within 59 feet of the liquor store?
I don't understand what the 59 feet accuracy is. I think that is actually the zoom in on the different things that.
Was there anything on that documentation that would state that that was not an accurate or area wherein he could have been in?
I can't testify because I don't know exactly what that means.
Okay, so he could have easily just been paying for his gas or something there at the counter, and the liquor store wouldn't have been no more 6-9 foot away.
Every other time that he had been there, that monitor had never been that far away from the store itself. Several times that he's been there, you could see in the store where we was, I'm sure, paying, and that wasn't where it was at.
Is there anything to depict that here today, evidentiary wise?
I can't.
Okay, all right. Now, as far as these other violations that are stated, as far as in Zaxby's, I mean, stopping to get something to eat, would that be something that would be violative of his conditions if he was working or taking care of his grandmother to do that?
It wouldn't have been, it would have been in the area that he's supposed to be.
Okay, and can you tell me what area that you had defined to him where he was supposed to have been at?
He lives in Monroe County. He lives very few miles outside of Tompkinsville. The Bolero station, just as before you get to Walmart, he frequented that station a lot. I'm sure getting fuel, getting cigarettes, whatever. He was right there at the log yard. Only in town, you know, where he was going to his grandmother's house. You know, he'd stop at Sonic, you know, he'd stop at the 5 Star. He went through McDonald's, you know, several different places that I didn't have a problem with. And, you know, he went and picked his dog food up. You know, I went along with that because I'm sure his dog was hungry too. And with, as far as going back to the things that he had to do for his job, you know, he went to Monroe Feeding Farm, you know, more than once. I was good with that because it was his job. He'd been to Bruton's and picked stuff up, and which, you know, I agreed with that because that was his job. And, you know, I tried to let him go the places that he could, but now I never agreed riding the bowling green and riding through the campus and stop getting chicken, go home was just a little off kilter of where he should have been.
Okay. So the 8/26/24 picking up dog food, that would be something that's fine.
Yeah.
And you also mentioned this Jeremy Carter residence. That's some relation to Mr. Carter?
I'm sure it is. I don't know. They've got the same last name. I'm sure there is a relation there somewhere.
And did you ever speak to Mr. Carter, Brockman Carter, about why he was stopping there at this?
I asked him why he kept going back and forth to Jeremy's, and he said that he was, I don't remember how he said it, acquaintance or maybe part of his business or something.
Part of his business as far as the logging?
The logging, yeah.
Okay. Did you ever ask him to stop going there?
I questioned about it several times. He said it was something he had to do. That wasn't actually part of my complaints, you know.
Okay. All right.
I mean, it showed on the monitor that he was there, and Mr. Stockton himself had questioned, but.
Okay. So, I mean, in essence, as far as this 8/24 violation too, driving through Mount Hermon, did you ask him why he went through Mount Hermon or what his purpose was for that?
He was there like 5 o'clock in the morning at the store and turned around and went back home.
Okay. So he just went to the store and went back home?
Yeah, several miles away from his house.
Okay. Is that something that stuck out to you as a violation as far as, I mean, that's still in Monroe County, correct?
Well, I mean, you know, it's a gas station. I'm sure at 5 o'clock in the morning, you know, they probably got a breakfast sandwich, but now he passed multiple places that he could got the same thing instead of going on the far end over in Marion County.
All right. As far as the violations that Mr. Stockton has brought up, they seem to have started sometime in August. From April through August, was he compliant with everything and done everything you asked him to do?
Other than just a few times he let his monitor go dead, and he was usually pretty good, you know. I'd call him, he'd plug it back up, you know, he'd do what I asked him to do.
Right. And you also testified that Mr. Carter sometimes was, let's see how he stated it. I believe he said that he was antsy and moving around, bouncing around a lot. You've known Mr. Carter a long time. You would agree that that's his personality, or would you not?
Yeah, but whenever I go through the rules with them, there's a lot of things that I ask them not to do. One is to be easy on my monitor and the charger and stuff, because,
yes, sir.
You know, if you tear it up, you know, you have to buy a new one, you know, and that he sat there and pretty much intentionally made it quit working.
Okay. Just by bouncing around and being nervous.
Stomping on the cord, it finally quit.
And he had stated to you prior to that that the monitor was, or that the charger was messed up.
But he had never made any contact with me saying that it was messed up to get one.
Okay, but when you called and told him, he come straight into your office and took care of it?
It's an asking nature. We've been over this 3 times. Let's move on. Okay.
Yes, sir. I think that's all the questions I have.
I just have one question.
Deputy Richardson, you said you weren't aware of any drug or alcohol use, Mr. Carter.
correct.
Were you testing him?
No.
Okay.
Call your next witness.
Yes.
Judge, I got one other question. Have you got a copy of the rules and regulations, things that you asked Mr. Carter to sign?
I don't have it with me, but I do have it in my file.
You can provide it to counsel.
I will.
Yeah.
That's not a problem.
We're looking to officer, if you come around. Thank you. You want to raise your right hand, please. You swear the testimony that gives the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Stay seat there. Speaking about how station you're employed.
Lucas Geralds. I'm employed with the Monroe County Sheriff's Department.
Deputy Gerald, as part of your duties to serve arrest warrants,
It is.
and did you attempt to serve an arrest warrant on Brock Carter?
I did.
And when was that?
September the 10th.
And what time of day was it?
That was around 7 p.m. when this started.
So was it kind of getting dark or?
Yes.
Okay. And who went with you?
Trooper Trent Tooley with Kentucky State Police.
And was anybody else there to arrive at later?
Not not at that time, but I did call for an extra unit.
Okay. And who actually arrived?
That would have been Tompkinsville Police Officer Aaron Capshaw.
Now, where does Mr. Carter live?
He lives about 2.5, 3 miles out of Tompkinsville, past Joe Harrison Carter on the old Edmonton Road.
Okay, just kind of set the scene. Does he live in a house? Mobile?
Yes.
Okay, brick, wood?
It's kind of a siding, looks log, but it's kind of a siding.
Okay, does the house set close to the road or is it off up the road?
Well, it sits real close to the old loop, and then it's just right on the backside of the new road.
Okay.
So
What did you all do then? What was the first thing you did when you attempted to serve the restaurant? Tell the court. what
So
happened.
we arrived on scene, which we're familiar with this place. We've been there before to serve an indictment on him previous. I went to one door. There was 2 main entrances into this house. I went to the one and Trooper Tooley went to one. So we knocked, announced loudly. You know,
Knocking
me.
loudly.
Yes, we knocked loudly, we announced loudly. Myself was the sheriff's department, it's Lucas. Trent would do the same thing on a different door, you know, Trent Tooley with KSP. This went on and on and on for about an hour. During that time, I contacted Ricky Richardson and I asked Ricky to try to make contact with him via phone. He did. And when I was standing outside, there's a window beside one of the doors to the house. I could hear Mr. Carter talking to what I assumed was Ricky at the time. And then all of a sudden, Brock got really agitated. He was yelling, cussing, and then it went silent.
Did you see him or just hear him?
At that time, we just heard him.
Okay.
So I did call Ricky right back and he said, yes, that was him. And I said, okay, we know he's in there. I relayed that to the trooper. At that time, I called for another unit, Aaron Capshaw, to come on scene, because we did have a basement in this house too that we could not watch.
The two that you couldn't secure the
right,
residence.
Right.
Okay.
So at that time, when Capshaw got on duty, everybody was in their place where they're supposed to be. There's one of the windows by one of the entrance doors had like a part of the shade that was messed up, so you could actually see into the living room, kitchen area. The door that I was standing on had a pole wedged up under the door and down into the floor.
Was it like a metal or wooden post?
Yes, like a metal post,
Okay.
to keep you from gaining entry, more or less. You know, during all this time, we keep hollering at him, you know, with the sheriff's department, state police. We have an arrest warrant, just come on out and take care
During
of it.
this time, and especially after you find out that Mr. Carter's in the residence,
Yeah.
do you ever get any verbal response or anything from him?
No, but what we did, myself and Trooper Tooley, observed Mr. Carter sneaking across, from a hallway across the kitchen living room area, while we was watching through this blind, we seen him come
When
across.
you say sneaking, what do you have?
Well, he was basically just hunkered down, going across slowly,
Okay.
and trying to be quiet, I guess. And we then, after that happened, that's when I started advising him, Brock, we do not want to damage your property. You need to come to the door now. Let's get this over with. If you don't, we're going to make entry. We said this 2 or 3 times. Trooper Tooley done the same thing. At that time, he never would respond. So we knew that we couldn't get in the door that the pole was on. There was no way he was gonna breach that. So the other door had a double glass door. So we then gave him a final command to come to the door, or we was gonna bust the window out of that door. And at that time, Trooper Tooley took out his asp and he took out the glass of one of the doors. I then went through the inside, unlocked it. We made entry into the house. I flanked left, Tooley and Capshaw flanked right, cause I had a hallway, they had a bedroom. As I come around, we all had our guns drawn, not knowing what to expect when we come in. But as I come around the corner, I could see Mr. Carter laying in the bathroom floor. I started giving him commands to show his hands. We started approaching him. At that time,
Did he ever show his hands?
yes and no.
Okay.
So he didn't want to abide by any commands we was telling him at first. I told Officer Capshaw to switch to non-lethal and go taser. Myself and Tooley were still lethal. And while he was on the floor laying, he tried to take his left hand and kind of run it towards the toilet. Obviously, we don't know what he's reaching for. At that time, I advised Officer Capshaw to tase Mr. Carter, which he did, and he was still resisting, still not listening to our commands. We did finally get him cuffed and brought him into the living room, set him down. At that time, he was, he was still resisting, trying.
When you say resisting, in what way?
Pulling away. He pulled away from the trooper twice. Trooper Tooley then got him in an arm bar and took him into the living room. And then we set him on the couch. We put his boots and stuff on him. And then at that time, he was taken out to the trooper's car.
Okay. Now, was he tased once or twice?
Just once.
Just once. Okay. Did he say anything during all this?
Yes. So he kept telling us that warrant is, that's not a warrant. There's no signature on that. There's no way that warrant is active on him. And I kept advising him and showing him where Judge Williams had electronically signed this warrant. He said, I don't care. It's a bogus warrant. No, it's not a bogus warrant. So anything we would say, he just had something to say back on it. And that's kind of where it went. We took him to the car. And that was that.
Okay. And the resisting that he did was attempting, I guess, to break away from the officers.
Yes.
Okay. And he never once, that I could tell, followed any commands for you to assist you in the arrest. Did he?
None at all.
Okay. I don't have nothing further, Your Honor. One other thing, you said you had your gun drawn. Did you think of this, after looking back on it, this was a dangerous situation for everybody?
Absolutely. We all thought this was an absolute dangerous situation.
Okay, nothing further.
Well, thank you, Judge. When y'all went up and started beating on the door, y'all beating on 2 doors?
Yeah.
And it was dark outside?
Yeah.
Any lights on outside?
No.
Any lights on inside?
There is a security light on the back side where the trooper was at.
Okay, but not where you were at?
No.
And was any lights on inside?
Yes.
Okay. And during the time that y'all were knocking and stating that you were doing this loudly, you never got any response whatsoever from Mr. Carter?
No.
No verbal response, no threats, no nothing?
Nope.
And then, you were actually only able to know he was there when he talked to Mr. Richardson, is that correct?
And then we we actually observed him
afterwards?
coming, yes.
Okay,
So we had two different instances that led us to believe, well, we knew that he was in the residence.
okay. Now, you stated that y'all were outside knocking on the doors for an hour?
We was there close to an hour, yeah.
Okay. And, Mr. Carter, I'm assuming, was able to move around the house anywhere, do whatever. He never tried to escape, knock out a door, run from y'all, anything of that nature.
No,
And you said you finally knocked out a glass, y'all breached into his house, guns drawn, and you saw Mr. Carter lying in the floor in the bathroom?
yes.
Okay, what did he have on?
Jeans, no shirt, no shoes.
No shoes, no socks?
Nope.
So you was able to see everything about Mr. Carter. Was he doing anything at that point to be threatening to you or
The only
the other
thing,
trooper?
the only thing that bothered us is he would not listen to our commands. We just want you to put your hands up where we can see them. And as we was approaching closer, he took his left hand and started to run it behind the toilet, which of course at that time, we can't see everything behind the toilet. We don't know what he's reaching for, if there's anything there or not at that time. So,
Well, the lights were on in there, correct?
yes.
So he's able to see plainly.
No, it wasn't plainly. There's a corner there. We couldn't see everything behind the toilet.
Okay. During the whole time that you observed Mr. Carter, though, he made no threats toward you, correct?
No, no threats.
Never verbally or through his bodily actions, correct?
There was some bodily actions.
How would you say that when you said he was laying in the floor of the
Well,
bathroom?
that's not the point. When they got him up and we tried to get him cuffed, he kept jerking away.
Okay.
Okay?
Up to this point, before you got him up, he had not made
No.
any kind of threats towards you whatsoever.
No.
And when you got him up and you say he was trying to jerk away, I think Mr. Stockton put it as break away. But explain to me or the court what you mean by jerk away. Just want you to let go of him?
Yeah, basically when you're trying to cuff somebody and they're just pulling away from you, we're trying to keep you from cuffing them, is what it is.
And he was stating to you that he didn't believe there was a warrant out for him, that this wasn't correct.
I mean, I had the copy in my hand, showing it to him, showing him the signature, everything, you know.
I'm asking you, that's what he was stating to you,
Yes.
his belief was,
Yes,
right?
yes.
Now, you stated that you thought this was a dangerous situation, but Mr. Carter hadn't done anything whatsoever to make you believe it was a dangerous situation. Would that be fair?
No, that's not fair. I know Mr. Carter, known him for a long time. Generally, like when I went there in the past, when state police was there, I went and knocked on the door, Mr. Carter come out fine. You know, this time, after I heard how agitated, how he was yelling and cussing when he was on the phone with Richardson, that kind of changed our tactics a little bit. Because he was yelling like at the top of his lungs, just cussing, and then that changes things.
Nothing about getting a firearm or
No.
harming nobody or hurting anybody in any shape, fashion, or form?
No, no.
Okay. Once you got him up, you put the handcuffs on him, set him on the couch, put his shoes and everything on, y'all went to the jail. Didn't make any threats to you, nothing of that nature?
No threats.
Okay. And aside from him yelling on the phone, that was what caused you to believe it was a dangerous situation?
Possibly, yeah. I mean, that changes things. I mean,
Just
I know
yelling
the
on the
difference in
phone.
somebody being, you know, really agitated or, you know, what's going on here, you know.
And I'm assuming y'all tased him because he wouldn't let loose of the commode, is that what the deal was?
That was the reason he got tased. He would not listen to our commands of keeping his hands up where we could see him, and then he took one to try to run behind the toilet. That's whenever he was tased.
Well, I was told that he was trying to hold on to the toilet, that's what the statement was. Was
I
that
don't know
he was
what you'd
trying
be
to do?
holding on to the toilet for at that time. 'Cause we
Grab
hadn't
hold of
even-
the toilet, and hold on to it.
If he was, I don't know why he'd be doing it at that time, because we hadn't even got close enough to him to where we could grab him yet. We were still trying to see his hands.
Okay, that's all the questions I have, Judge.
No way there. So I should be excused. No other way. Hear me, please.
Judge, it'd be against my advice to testify, Brock, but I'll leave it up to you. I wouldn't
can,
say
yes, sir.
anything.
Okay, I
Are you
won't
good
do
with
it.
that? All right.
Yes, sir.
We're gonna do it.
The whole point of this is that Mr. Carter has almost made a mockery of the home incarceration system. Everybody want to be on home incarceration if they could go wherever they wanted to. I don't care if Mr. Carter was in the liquor store or the grocery store at Summer Shade on July the 25th. He had no right to be in Summer Shade. He had no right to be in Glasgow. He had no right to be in Bowling Green. None of these places he went to. And then to create this situation that he created on September the 10th, endangering himself and the officers because of his noncompliance, I don't see any way in the world that he needs to be out on bond at this point in time because he will not comply.
Your Honor, Mr. Richardson stated that he could be in the store there at Summer Shade.
No, listen, I hate to object, but I asked him specifically, I said, would he have permission to be in something? He said, no.
Well, I just sat here and thought I asked him, Judge, on September 25th, if he could have been there. He said, yeah, he could have got fuel or something of that nature. You heard the testimony. I'll let it lay where it lays, Judge. The bottom line is from all the way from April up until August, it seems like to me that Mr. Richardson testified that he had been compliant, done everything he was supposed to have done. There was no testimony given of anyone calling and saying to Mr. Carter, hey, you can't do that, you can't do this. He had permission to take care of his grandmother. He had permission to do his logging business. Judge, I've been around enough time to know that when you're logging and things of that nature, there's a lot of things that goes along with that. Even with the Jeremy Carter situation, Judge, it's not clear if it was stated to him, you can't be there. I mean, he was talked to about it. He said it was something he had to do as part of his business. And there was no violations filed on that. There was no violations filed on any of this until just this last few incidents that we're here about. As far as them going into his house, Your Honor, I could stay here and state, yeah, I mean, he could have walked out, Judge, but he also has the right not to, in my opinion, if you don't want to open the door. But he was in the house for an hour. They said he thought it was a dangerous situation. Mr. Carter never done anything except from their own testimony, snuck through a hall and went and laid down in the bathroom. He never made any kind of actions or took any type of steps.
So let me ask you a question. I find that to be very interesting. So you're saying if officers appear at a residence with a lawful warrant to seek someone's arrest, they know the person's inside. They hear the person yelling and screaming and cussing on the phone, and they look in the window and see him sneaking around, that they do not have the right to breach that to make the arrest. Is that what your position is?
No, my position
I'm
is,
asking you, is that your position?
that's not my position.
Okay, I just want to make sure.
My position is if I was in my home, in my house, and somebody came up there, I can't sit here and say to the court, I wouldn't try to hide. You know, I wouldn't want to go to jail, be afraid.
I'm not saying he didn't try to hide. I just say, can you lawfully refuse to come to the door and not get breached?
Well, I mean, no, I'm not saying that, Judge.
I just want to make sure that you had some authority on that, but go ahead.
No, I'm not trying to state that, Judge. I'm just trying to
I'm just
state,
trying to understand. Go ahead.
I understand. Judge, there's clearly some violations here of going places he shouldn't have gone, but there's no drug use. There's no new violations. There's no alcohol use that's been proven here today in any shape, fashion, or form. And he's not done anything to try to harm anyone in any way. And I would ask the court to at least consider sanctioning him and letting him back out and giving him the opportunity to comply. As I've stated to this court, Mr. Carter is someone that has been in the 2 different deployments. And as I've talked to him myself, sometimes he's been.
You can't testify in this case. You cannot testify.
Well, I'm not testifying.
You are testifying. You're giving information that you observed yourself. If you want to bring a witness, you can do that. Okay.
I think everybody, Mr. Stockton would stipulate that he's been in 2 tours of combat and that he's on
I understand that's been testified to before.
Right.
I'll take that into consideration.
I would ask the court to do that. He is under the care of the VA at this time. I just don't think he's done anything to pose a risk to anybody. Has he done exactly what he's supposed to do? No, sir, I would state that.
Do you have anything in response, Mr. Tyler?
Now, this is probably
the most egregious case I've ever seen since we've been doing home incarceration, somebody not complying. And I've been getting complaints on him for some time. And I don't mean to testify, and that's the reason we're having this hearing today, and I subpoenaed these records. And those complaints borne out to be true.
What's the underlying charge?
He's charged with fleeing and evading, doing about 90 miles an hour through town, and he's also charged with hitting another vehicle. Wanting in danger.
See, here's the problem that I have. I know Mr. Carter through his family. I don't know him that well. But we have a series of situations here where his failure to comply with the law, flee and evade, strike somebody, goes over there to arrest him. He's lucky he didn't get killed. I'm gonna tell you what, with the world we live in, I don't know how many police officers will let someone who's non-compliant and reach behind something and wait to see if they bring something out and don't shoot him. And so I'm not only interested in protecting the public, but I'm interested in protecting Mr. Carter from himself and his own actions and these police officers who have to go over there and breach and go in. And I will tell you, if they'd breached and gone in and he'd shot one of them, we'd have a castle doctrine sort of argument going on whether he had the right to protect himself. So I want you to get your calendar out and let's schedule a speedy trial for Mr. Carter, but he's going to be incarcerated until that. I'm revoking the bond and he'll be incarcerated until we have a trial, but we're going to get him a speedy trial. And you have everything ready to go on the trial?
We're all local.
You have your calendar with you?
I do.
Okay, let's get a calendar out and get him a speedy trial, because he's got a right to.
Your Honor, I would say to the court, me and Mr. Stockton discussed this case yesterday. And we're moving toward some type of situation
Well,
here.
I don't know that, but I'm going to tell you what, if you don't want to schedule him a trial today, we can go ahead and schedule him for a negotiation day if you want to.
Either one's fine.
Let's do a negotiation day and then the next Monroe County, when's the next?
Judge, I don't care to do a speedy trial if that's what the court wants.
Well,
I'm fine with that.
If you're not requesting one, I won't give you one. But if you want to do a negotiation day instead of trial the next rule day, that's fine also. Either one you want to do.
Well, let's just go on and set it. If we can get it worked out before then, that's fine.
Is Commonwealth versus Owens going to be held on October 9th?
As of right now, I don't know of any reason not to be.
And that week I'm out.
He's out.
We've got Monroe County trial, Commonwealth versus Marley.
That couldn't be superseded with this trial. That's a possession trial. We can do that later.
And let's double schedule.
Okay.
And if you.
That's October 3rd.
So that's on Thursday the 3rd.
November the 3rd. October the 3rd. Fine with me.
Okay, thank you very much. Okay. Barron County, thank you very much. You may be excused. Now let's go to let's go to Hopkins County if we can. Hopkins County, are you still on there? And then we'll come back to Taylor. Hopkins County, this is Commonwealth of Kentucky versus Gerald Becker, 22 CR 00106. Motion for shock probation. Are you Gerald Becker? Mr. Becker, you can turn that microphone on there. Little red microphone there. 22 CR 00106, Commonwealth of Kentucky versus Gerald Beckner. It says D on here. It's public advocacy involved in filing this motion. Are you Gerald Beckner? Mr. Beckner, say
Yes, Your Honor.
something now. Let's-
Yes, Your Honor.
Born in 1977.
Yes, sir.
Were you born last four digits of social security number 4499?
Yes, Your Honor.
What do you have? Did you all file this for him?
We did at the defendant's request, we filed a motion for child probation. Your Honor.
Tell me about it.
Judge, we would rest on the pleading. We know he's coming up for parole October 25th now. If the court would like to pass this to the
Now,
November.
Mr. Beckner, you're coming up for parole on October 25th. It would be to your advantage to make parole rather than be probated. So what I'll do is I'll hold this in abeyance and move this out till the November 21st rule day here. And if you're not granted parole, then we'll take this motion up on that day. I think that would be to your advantage. You understand?
Yes, Your Honor.
Thank you very much. Hopkins County, you may be relieved, and thank you for your patience, cooperation. Let's go to Taylor County Detention Center. Are you Oscar Fairley?
Yes, sir.
This is 24 CR 0020, Commonwealth of University of Oscar Fairley. Were you born in 1992, Mr. Fairley?
Yes, sir.
Last four digits of number 43.
5643?
5643, yes.
Yes, sir.
We're here for a pretrial conference. DPA represents Mr. Fairley. What do you have to say?
Your Honor, it's gonna be some time before we're ready on this case because we had one lab report back. And then there's other things that needs to be taken to the lab and they won't be taken till the 1st of October.
Do you want to schedule this for November 21st?
That'd be fine.
Okay, with y'all, or do
For us,
you want to have a negotiation day in 21st, or you just want
I will schedule it, when we schedule one in November, we'll do an agreed order.
to? Mr. Farley, they've got some discovery that they're still doing in your case. Your attorney will be up to speak to you. We schedule it for November 21st, but if the discovery comes sooner, then they'll say that they'll schedule you sooner. Okay? Okay, thank you very much. Taylor County, thank you for your cooperation and the excuse.
Thank you.
Russell County. Yeah. Okay, let's pray. Let me do Russell County real quick.
This one,
Russell County Detention Center.
this hearing will take a little bit of time, so I don't.
It's a hearing.
Yes.
Okay, well, hold on there, Russell County, and we're gonna bring the grand jury in here and then we'll take you out. Y'all clear this area over here, please. Y'all come sit over on this side over here somewhere. You know, just go back there somewhere. If you bring your grand jury in. Mr. Stockton, Ms. Gordon Anderson, when we do the Candy and Jonathan Stuber, are they the same sort of, their
Co-defendants.
their probation revocation, are they the same underlying issue?
Well, we're gonna request, they have court also in Clinton County on 10/10. And we were gonna ask the court hear everything on October 10th.
It's the same motion, it's the same motion filed for both counties.
Well, we'll have to address that when we get to it.
All rise, Cumberland County Grand Jury.
And take your cap off. Yes, I am. Okay, everybody be seated. Here's the form of the grand jury. Mr. Foreman, will you deliver your decisions to the bailiff? Mr. Foreman, did 9 or more of you agree on the actions you just presented to? Yes, sir. Hey, ladies and gentlemen of the grand jury, I'm executing a document here that will authorize issue of warrants to serve the indictment on the individual that you have charged. I want to make sure that you know that you need to keep this confidential, the actions that you've taken for the safety of officers and for the safety of the individual involved. It's my grandfather used to say people get scarce sometimes if they know things are coming and cause problems. So the next day that y'all are to be in is October the 24th, unless called back in for reason of riot or insurrection or something like that. You can't ever tell these days when you're going to have a riot or insurrection. It's troublesome times. So you're now excused. All rise for the grand jury. If you'll follow out this way, and y'all can be excused. Okay, I'm going to call a case of Clinton County. If you'll turn your camera on. Had Jonathan Stuber and Candy Stuber in Russell County. If y'all unmute your microphone. So you're Jonathan Stuber.
Yes, sir.
Born in 1988, last 4 digits, social security number 2587.
Yes, sir.
We previously identified Candy Stuber, who is in the Russell County Detention Center. Now, DPA represents both of these individuals. You want to come up and did y'all reach some kind of agreement about hearing these someplace else, or what do you tell them?
No, Your Honor, I was under the impression we were having the hearings today.
Are the same allegations, violations the same on both of these co-defendants?
Yes, they're very similar to them.
You represent both of them. They previously waived dual representation. So you ready to proceed?
We're ready to proceed.
Call your witness.
Okay, I call Carson Payne.
Judge, on behalf of the Stubers, before we get started, we were
speak up a little bit.
On behalf of the Stubers, before we get started, I would ask that the court consider hearing these on October 10th. We just received this motion last week to give us time to speak with the Stubers and prepare for the hearing.
You have any objection to that?
They're going to be held, and as long as our witness is going to be available on Clinton County motion
Will
day.
you be there on October the 10th?
I'll be there, sir.
So we'll continue this with Clinton Circuit Court on October the 10th. Okay, we'll be in contact, your attorney will be in contact with y'all, the Stubers, okay? Clinton County, you may read, thank you for cooperation. Russell County, thank you for cooperation. And Russell County Jail, are you still there? Somebody in there? Okay, y'all both may be excused. Thank you very much.
Judge, may I be excused? That's all I have today, sir.
Thank you very much.
Thank you.
Okay, let's go back. Dustin Dalton, live docket. Dustin Dalton. Active warrant NCIC, take a look at that. Albert Davis. Albert Davis. Are you Albert Davis? Yes, sir. Good morning. This is 24 CR 0063 Commonwealth Kentucky versus Albert Davis. Mr. Davis, were you born in 1971? Yes, sir. Last 4 digits, social security 8453. Yes, sir. Okay, this is a pre-trial conference. What has the Commonwealth to say?
We have a felony plea, Your Honor.
Okay. Mr. Davis, a motion's been tendered and says that you wish to enter a plea today. Is that correct? Yes. Is that correct? Yes, sir. Okay. Are you currently under the influence of drugs or alcohol? No, sir. Is this plea freely and voluntarily given? Yes, sir. Are you the same person that was just identified in case number 24 CR 0063? Yes, sir. Is your judgment impaired today?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yeah.
When you read the evidence Commonwealth has against you, you believe you've been fully informed about your case.
Yes.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky United States Constitution. Before I can proceed, I need to know you understand those rights. I'm going to read the rights to you and ask you if you understand. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel for jury trial. Right to confront and cross-examine all witnesses to call testify against you. Right to this evidence. Right to call witnesses in favor. Right to appeal this matter to higher court if you lose. And right to file a complaint prove on a reasonable doubt that you're guilty charged against you. Understand by entertaining a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation that I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to post harsh punishment, give the right to withdraw your plea. Mr. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall pay fines and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you didn't commit the charge in your indictment as amended?
Yes, sir.
Doing so of your own free will?
Yes, sir.
Reading constitutional rights explain to you still your desire. You have those rights. Enter plea of guilty, allow the court to fix your punishment in any range prohibited by law.
Yes, sir.
Do you understand by entering this guilty plea today, any future conviction could be enhanced as far as the penalty and the persistent felony federal law? You understand that? Is that your signature on the offer?
Yes, sir.
Yeah, I will accept the offer. And you need to meet with a probation parole officer there. Now, this was a probated sentence, so I'm going to allow you to remain out on bond. If they meet with the probation parole officer there.
Thanks.
Schedule sentencing on October the 24th, okay?
Yes, sir. Thank you, Judge.
Okay, thank you. Paul Gross. Paul Gross. Morning, Mr. Gross. Commonwealth Kentucky versus Paul Gross, 24 CR 0064. You are Paul Gross. You were born in 1976, is that correct?
Correct.
Okay, the last 4 digits, social security number 9749. You're here on a pre-trial conference. Mr. Stockton, what do y'all have on this case?
I couldn't tell from Mr. Pennington's email. Are you all getting conflict counsel?
Mr. Gross has a co-defendant, DeJuan Maxey, 24 CR 66, Judge.
Yes.
We will be required to get conflict counsel for that. Ask the court to pass this out so we can get conflict counsel.
They have conflict counsel available, appointed, available on October 18th. There'll be a negotiation day. That conflict counsel should meet with Mr. Gross before then.
Mr. Gross would be ours. Conflict counsel would be for Mr. Maxey.
Okay, well, then you have him here on October 18th for negotiation, and the next legal day be on October the 24th. Okay, when I get Mr. Maxey up, let's call him up now, okay? Mr. Gross, those are your 2 dates, your conditions of your bond, both of them. Commonwealth versus DeJuan Maxey, 24 CR 0066. You are DeJuan Maxey.
Yes, sir.
Born in 1969.
Yes, sir.
Last 4 digits, social security number 9653.
Yes, sir.
Okay, you're here at a pre-trial conference. You heard that Office of Public Advocacy is going to seek, are you going to represent him?
Yes.
Okay, good. Okay, you have new counsel here. You'll be here on October the 18th at 9 a.m. for negotiation, and your next court date is October 24th. Mr. Maxey, and both of those are conditioned for your bond, okay? Okay, Joseph Massey. Joseph Massey. Commonwealth versus Joseph Massey, 24 CR 0035. Are you Joseph Massey?
Yes, sir.
Born in 1957. Yes, sir. Last four digits, social security number 5077, you represent by Metro Poindexter. Here for pretrial conference, what says the Commonwealth?
I believe we have a pretrial diversion. Yeah.
Is that correct, Mr. Poindexter?
Yes, sir.
Mr. Massey, a motion has been tendered that was just acknowledged by your attorney that you wish to enter a guilty plea to that. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? This is just a plea freely and voluntarily given. We just identified you as an individual indicted in 24 CR 0035. Is that you?
Yes, sir. Yes,
Okay, is your judgment prepared today in any way?
sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
I am.
And review the evidence the Commonwealth has against you, and you believe you've been fully informed about your case.
I
You
do.
understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution before I can accept your plea. I know you need to know you understand those rights.
Yes,
I'm going to go over them, then I'm going to ask you to acknowledge that you have the right not to testify against yourself. I'm going to make you say anything, right to speak trial, but jury, right to be represented by counsel to jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses to favor process issue, attendance. You have a right to appeal this matter to higher court if you lose, and right to part of the Commonwealth without reasonable doubt that you're guilty charge against you. Understand that, man? Give up those rights. You understand that?
yes, sir.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law if I give you something more severe than the recommendation of the Commonwealth. However, you have the right to withdraw your plea. Will the Commonwealth come forward with your offer?
Yes. Excuse me. Mr. Massey will plead guilty to possession of a controlled substance first degree, have a 3-year sentence, pretrial to verdict for 5 years. He'll plead guilty to operating a motor vehicle under the influence, first offense, receive a $200 fine. He'll be recommended to the SSC, follow all recommendations, pay fine and court costs at discretion of the court, obtain, maintain gainful employment, and all evidence in this case be destroyed.
Now, is that what your agreement was?
Yes, sir.
Have you previously been pretrial diverted in the last 5 years?
No, sir.
You have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you complete the diversion, the charges would be dismissed, pretrial diverted, you can get a portion of your record expunged with the exception of the DUI. You understand that if you do not fully complete the diversion, you will be brought back before the court will schedule a hearing, sentencing hearing, and you will be a convicted felon. And then in that circumstance, any future felons could be enhanced by the virtue of this book. You understand that?
So,
You understand it because of DUI, but any future DUIs can be enhanced. You understand that? You do understand that?
yes, sir.
Okay. Now, are you pleading guilty because you did commit the acts as charged in the indictment as amended?
Yes, sir.
Doing so your own free will.
Yes, sir.
Under constitutional rights, you can agree to let the court fix your punishment within the range of the law.
Yes, sir.
Is that your signature on the document?
Yes, it is.
Except, well, has he got his DUI papers filled out?
We do, Your Honor.
You'll accept those and turn them in there. What are the court costs of that?
$875.
$875. Is you having to pay that, sir?
Yes, sir.
Okay, I'll let you pay it at $50 a month, starting 30 days from today. And you pay it sooner than if you like. $50 a month, starting 30 days from today. You don't need to be the probation parole officer right now.
Thank you, Your Honor.
Yeah. Kiana Mitchell. It's an active warrant, Mr. Stockton.
Yeah, we'll put it in the IC.
Joshua Norris, active warrant.
Same for him.
Brandon Polston. Have to look up and see if it's still morning, Mr. Polston. So it is. Good morning.
Good morning.
Commonwealth versus Brandon Polston, 24 CR 0050 for a pretrial conference, 24 CR 0074 for an arraignment. Mr. Polston, were you born in 1984?
Yes, sir.
Last four digits, social security number 6513. Yes, sir. Could you give me an indictment for the arraignment? You're represented by the Office of Public Advocacy. You have the right to remain silent. Grand jury of Cumberland County is returning an indictment charging you with trafficking and controlled substance first degree first offense. You acknowledge the identity of your client receiving indictment away from where you are and there plead not guilty, reserving all the trial motion.
We do, Judge.
I'll be signing a reciprocal discovery order, Mr. Paulson, to give you additional information to help prepare your case. Thank you. Be here on October 18th.
Your Honor, this is one, well, like Mr. Farley, we're waiting on the labs because we do November the 15th.
November the 15th.
I'm sorry, November 21st.
That's when's the November negotiation?
That'd be November the 8th at 9 a.m. here.
November the 8th at 9 a.m. and November 21st. Are your 2 dates. Both of those are conditions of your bond. Do you understand that?
Yes, sir.
And they just delivered additional information to help you prepare for your defense. Okay, thank you very much.
Thank you, Judge.
Johnny C. We're running. That was random stuff. Commonwealth of Kentucky versus John C. Good morning, Johnny. I haven't seen you. Mr. C, were you born in 1959?
Yes, sir.
Last four digits, social security number 8001.
Yes, sir.
Here for arraignment. Do you have an attorney?
Oh, he's supposed to be in here.
What is it?
I forgot the black dude. I don't know his name.
DBA. Yeah.
Yes, sir.
Yeah, he's not here, he's associates. Okay, so they'll stand in. And the grand jury of Cumberland County has returned an indictment charging you with wanton inducement of first degree, assault in the fourth degree, possession of drug paraphernalia, and possession of marijuana. Do you understand those charges?
Yes, sir.
You acknowledge the identity of your client, counsel received indictment, away formal reading and arraignment, and plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Mr. C, I'm signing the reciprocal discovery order where I have given you information to help prepare your defense. You're to be back here at 9 a.m. on October 19th for negotiations, and on October 24th at 9 a.m. for your next court date. Both those are conditions of your bond. Okay?
Yes, sir. Yes, sir.
October 18th for negotiation.
Right. And October 24th for pretrial. Roger Shreve. Hey, Johnny.
Yes, sir.
Stay away from the accused victim now, okay? Stay away from it. Okay? Okay. Okay. Roger Shreve. Good morning. Are you Roger Shreve?
Yes, sir.
You born in 1958?
Yes, sir.
Last four digits, social security number 70028. We're here in 24 CR 0040 for sentencing. You had an opportunity to look at the pre-sentence investigation, what we on the probation's role.
Yes, sir.
Is it substantially correct?
Yes, Judge.
Counsel, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon pleading guilty, possession of controlled substance and federally defendant shall receive 3 years probated, 5 years on plead guilty, failure to maintain insurance, you should pay a $500 fine. When plead guilty, operating the alcohol under the influence of the vehicle under the influence, $200 in court costs. Receive credit for time served. What's the total amount? $1,400. Now you understand that the DUI is enhanced. Understand if you another DUI, is that correct? You need to say something.
Yes, sir.
Okay. Do you need some time to pay the $1,400?
I do, sir.
Okay, well, can you pay $50 a month?
Yes, sir.
Okay, you pay $50 a month. First payment will be made 30 days from today. Since you have all the DUI papers and everything are finished today. So you need to meet with the probation parole officer right there. Okay?
Thank you, Judge.
Thank you, sir. Thank you. Wellesley Smith. Active warrant. Oh, is he here? Where is he? You make bond? Wesley Smith. For arraignment. Are you Wesley Smith? You have an attorney? Do you have an attorney? Okay, can you afford an attorney? You need to fill out an affidavit. Go with this gentleman here, fill out an affidavit. We'll come back to your case. Sean Wadley. Is that how you pronounce your name, Mr. Watley? Yeah. Good morning. This is 24 CR 0031. Sean, Mr. Watley, were you born in 1972? Yes. Last four digits, social security number 9513. Yes. Here for pretrial conference with Mr. Johnny Bell. Yes, that's correct. What does the Commonwealth have to say about this?
Do you have a diversion plea?
Mr. Watley, a motion has been tendered, the decision which to enter plea, they say correct? Yes. Are you currently going to say something? It's a voice activated microphone. Put him behind that microphone there, Mr. Bell. Are you currently under the influence of drugs or alcohol? No, sir. Is this free, plea freely and voluntarily given? Yes, sir. Are you the same number that the same person that we just identified in 24 CR 0031? Yes, sir. Is your judgment impaired today in any way? No, sir. Have you discussed this matter with your attorney? Are you satisfied with his advice? Yes, sir. Will you view the evidence the Commonwealth has against you? If you view the evidence the Commonwealth has against you, you believe that you're fully informed about this case? Yes, sir. And you understand that you do not have to enter plea today. You have certain rights under Kentucky and the United States Constitution. Before I can set the plea, I need to know that you understand those rights. Yes, sir. I'm going to go over them and ask you to acknowledge that, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel to jury trial, right to confront and cross-examine all witnesses called testify. Right to fix evidence, right to call witnesses in your favor. If I can fill this matter, how important you lose, and right to part of the Commonwealth to prove beyond a reasonable doubt that the guilty charge against you to be guilty, pleading give up all those rights. Understand that. I may consider the Commonwealth's recommendation, but I may have plain terms essential to that law if I have a harsh sentence that want to impose you on the right to withdraw your plea. Now, will you, Ms. Gordon Anderson, will you state what the agreement was?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle as required by KRS Chapter 304, the defendant shall pay a $500 fine and cost. Upon a plea of guilty to operating a motor vehicle, alcohol of or above 0.08, or while under the influence of alcohol or other substances, first offense, the defendant shall pay a $200 fine and cost. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in accordance with the laws of the Commonwealth and the holding agency.
Now, have you previously been diverted in the last 5 years? No, sir. Have you had any felonies in the past 10 years? No, sir. Are you currently on probation? No, sir. You understand if you fully complete the diversion agreement, the charges will be dismissed, pre-trial diverted, except for your DUI charge. Did you just show them proof of insurance or something over there? Or-
He provides us proof of insurance, if it checks out, we can do the pre-order, amending the police, that's all right.
Proof of insurance, the insurance violation is.
It's enhanceable time of offense.
It's enhanceable too.
It is, yes.
Okay, so both of those would be enhanceable. The insurance and DUI, and they've agreed to dismiss the insurance if the proof checks out, okay? So you understand that the DUI is enhanceable, but if you successfully complete the diversion program, your other charges will be dismissed pre-trial diverted, and you'll have them expunged from your records. You understand that? Okay, are you pleading guilty because you did commit the acts charged in the indictment? Yes, sir. Are you pleading guilty of your own free will? Yes. You know your constitutional rights to explain to you, is it still your right to go forth and enter a plea guilty to charge that in court to fix your punishment? Yes. That's your signature on the document. Yes, it is. Do you have his DUI papers filled out there too? He does. We'll accept those, we'll accept the plea. And what's the total amount of fine? $1,320. Now, you need some time to pay that. Yes, so you pay $75 a month? Yes, sir. Okay, well, the first payment's due 30 days, you pay $75 a month. That way, you know, won't infringe upon the rest of your life. You go ahead and meet with the probation parole officer. Thank you, Judge. Matthew Watson. Matthew Watson. Commonwealth of Kentucky versus Matthew Watson, 24 CR 0060. Are you Matthew Watson? Yes, sir. Born in 1996. Yes, sir. Last 4 digits of social security 1334. Yes, sir. And you're here on a pretrial conference. What does the Commonwealth have to say about Mr. Matthew Watson?
We have a lab on this. We don't have a lab, can we set this for October? You want it? I was in the process of getting the lab, we set this for October.
Okay, let's do a negotiation day on October the 18th. And then the next court date's October 24th. Both of them are conditions of your bond, Mr. Watson. You understand that?
Yes, sir. Judge, the defendant would ask the court to review bond, just the condition of no driving. He has a child that has sports activities, school things. He would ask that the court allow him to
What's he
drive.
charged with, Mr. Stockton?
DUI first,
And what else?
possession of controlled substance. First,
What would they do in district court? Boy, on the DUI first. What would they do?
No, I mean, on suspension.
Pre-trial, there'd be no
Wait
suspension.
just a second. Mr. Stockton, you have no objection to treating it as a way if it was a DUI in district court?
That's fine, Your Honor.
Okay, so your privileges will not be suspended. Is it the bond have him on a limit him to home, church, work, and doctor? Okay, well, I will go ahead and allow you to attend your child's athletic endeavors or school endeavors for your children. Okay.
Thank you, Judge.
Thank you. And I'm gonna go back to Wesley Smith. It appears Mr. Smith is entitled to representation by the Office of Public Advocacy. So in order of doing that, okay, you're here for the purpose of arraignment, Mr. Smith. Right, remain silent to represented by counsel. Now, the grand jury of Cumberland County is charged you with trafficking, controlled substance, first degree, first offense. You understand what that charge is? Okay. Counselor, you acknowledge that any client receiving that in a formal reading or arraignment or plea not guilty reserving all pre-trial motions.
Yes, Judge.
I've just signed a reciprocal order requiring the Commonwealth to give you information to help you prepare for your defense. You'll be here on negotiation date on October 18th and here for your next court appearance on October 24th, okay?
Thank you, Judge.
Barry Wilson. Barry Wilson. Commonwealth versus Barry Wilson, 24 CR 0037. Good morning, are you Barry Wilson?
Yes, sir.
Okay, Mr. David Cross representing you. Are you standing in for Mr. Cross? I'm sure you are.
And I don't mind too.
Okay.
See counsel, record judge.
Yeah, yes. He said he was gonna have somebody on the line to give us.
I don't mind sitting.
Yeah. Do we have anything except just?
Well, I got a motion to suppress about 2 days ago, so I guess we need to set it next month for a hearing.
Okay, let's set a negotiation day on October 18th. And the next court date is October 24th. And tell Mr. Cross that he hadn't settled it by then, that you'll hear the suppression on that. You got those 2 dates down then?
Yeah.
Okay, well, thank you, Mr. Wilson.
All right, thank you.
Yeah. Okay, we got one more, Kevin, I guess, Kevin Young. Young. Is that Kevin or Kevin?
Kevin.
Kevin. You spell it with an A?
Yes, sir.
Commonwealth County versus Kevin Young, 24 CR 0073 and 24 CR 0074. You are Kevin Young,
Yes, sir.
born in 1970.
Yes, sir.
Last 4 digits of social security number 6587. Is that correct?
Yes, sir.
Here, for the purpose of arraignment, you have your attorney with you. You have
Yes,
right
sir.
to remain silent. The grand jury of Cumberland County has returned several indictments to you. In 0074, charge you with possession of controlled substance, first degree, possession of controlled substance, first degree, possession of controlled substance, and third degree, possession of drug paraphernalia, and possession of synthetic drugs. In 34 CR 0073, grand jury has charged you with trafficking in methamphetamine, operating a motor vehicle under the influence, possession of marijuana, possession of drug paraphernalia, careless driving, failure to eliminate registration, and failure to signal. You understand those charges? You
Yes, sir.
understand what they are?
Yes, sir.
Okay. You acknowledge the identity of your client, counsel, received indictment, wait formal reading and arraignment.
Yes, sir.
Plead not guilty on all charges and reserving all pretrial motions.
Yes, Judge.
Mr. Young, I'm signing reciprocal discovery orders to comply with the Commonwealth to provide you information and prepare for your defense. You shall be here for negotiation purposes on October the 18th, 9 a.m. and your next court appearance is October the 24th. Both of those are conditions of your bond. Do you understand that?
Yes, sir.
Okay. Okay, now, is there anybody else here live and in person before we take a short break before we go to the jail docket?
Judge, on Mr. Young's case, he would ask a court review bond as well before we move on. Regarding his ability to drive. Apparently, there's a no driving bond condition he'd like to work.
Okay, what does he do for a living?
I was working in, Albany, helping paint a house and do
You were doing what?
construction and painting.
Okay.
And,
Well, you can already drive to go to work. Where does he want?
I'm not allowed to drive anywhere according to my conditions of my bond.
And you're going, I'll let you drive to go to work. You go to drive to church, work, the doctor. Are you a married person or
No,
live by
sir.
yourself?
Live by myself.
Okay, where do you live?
I live at the riverfront lodge.
Okay, well, you go across the street to the grocery, so you don't have to
Yes,
do
sir.
that. So if you go to work, church, to the doctor. Okay,
Thank you.
so it's a pre-trial number. If there's someplace else you need to go, you call.
Okay.
I guess he wouldn't be under any. The reason I'm doing that is because of the multiplicity of charges here. It's different than just a regular DUI. If you had just a regular DUI, I might loosen it up more than that. You agree with that comment? Okay. Okay.
Thank you,
Make
Judge.
those charges. Okay, well, that's the last person live here. Is there anybody else back there that wants to volunteer to come in front of the court before we take about a 5-minute break? Yeah, what do you got, man? That'll be the show cause docket. Y'all just wait around. Just wait there. We'll do the show. Your cause docket. Okay, we're gonna take about a 5-minute break here or less. Okay, go off the record.
Sure, you got much more.
We're gonna do that. So look where he's at. So you can't see these.
Yeah.
Right.
I think still need to. Say so.
No problem.
He needs first license.
Yeah, one of the partners. He is in a family court hearing, and I get to come down here. I did have a choice to do a full family court hearing. I said, you know what, that is not for me. No, I know nothing about that. I know a little bit.
Trying to keep it all straight, stuff. Living the dream, how are you? Trying to keep all this straight up.
I got you.
We don't want to give you a hard.
That's one thing I had.
Of course, of course. I appreciate y'all having me. Just more. 3 month contract.
And if so, like, one opportunity, you know, those kind of areas. It's just. They can.
Right, I guess.
And then, yeah. If that, then other questions and all of that. Mine's here. My only question was. In front of her.
Lloyd.
Just recently, we didn't start on district board instead of just.
I know. Right. And it's polite, it just tells you that.
First one, I've been about 6 months. Yeah.
The very.
I got one of those people.
Oh.
Yeah, yeah, it was cool. Don't pay for the valuation. That's the worst. It can't be a felony level. I think the creator of it is the bad. I don't think that's what. We have 4 hits together, all their degrees, it's right there, and it's like it's the last year. We found Holocaust, some things. Wow. He stopped and go public things. My bad. Okay, let's get back to order and go. County Jail docket.
Your Honor, can you take one case out of order in jail docket? Officer Garner's got to go downstairs for a parole here in a few minutes. Yeah, please. Stephen.
Who you want?
Stephen Tennant.
Stephen Tennant. But you said Stephen Tennant.
Yeah.
Okay, Dare County. You give me Stephen Tennant, please.
Present.
Commonwealth versus Stephen Tennant, 21 CR 0027. Mr. Tennant, were you born in 1973?
Yes, sir.
Last 4 digits, social security number 7763.
Yes, sir.
Okay, we're here for a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, he has a 3-year sentence on possession of controlled substance. He was arrested in Overton County, Tennessee, August 14th, 2024 for possession of methamphetamine. Then on August 21st, 2024, he was arrested here in Cumberland County for DUI. And we have a positive meth test after that arrest. Now put Officer Garner on the testify.
Pled guilty to that yet?
No, he has not.
Neither of those cases have been resolved yet, Judge. I was under the impression we were going to request for Mr. Tennant to attend specialty court, drug court after our negotiation day.
Well, I told you if you could have him assessed and if maybe we could look at that either maybe sentencing or something. That's our shock. I don't know. I'd be up to the course, but that may be something.
What was his underlying felony?
It's a possession case.
And we had DUI since then.
Well, he had the charge with the new felony in Overton County is alleged his passenger had meth in a cigarette package, and then there was a little bit of meth in a backpack in the vehicle. And then he had the DUI here in Cumberland County on the 21st. He was charged with Deputy Watson, and Deputy Watson wasn't available today because he's doctor's appointment.
You stipulate to those violations, and then we'll see what happens in the district court on the DUI, and then we'll come back here and decide what we do on it.
Yeah, and I don't mind to have him assessed in the meantime if Ms. Carter wants to do that.
That'll be fine, Judge. I've got it's right here.
Okay. That'll be fine. We can until October the 24th. Tara Dykes.
Another court date for. I think you said that.
Mr. Gabbard. Mr. Gabbard. No, it was Mr. Tennant, excuse me, Mr. Tennant, you want to come back? Did you hear what was going on, Mr.?
I believe so. Did you reschedule? You reschedule court date for the 24th of October?
To see if you're eligible for drug court, and they're going to wait to see what happens in your district court DUI case and your case down in Tennessee. Okay.
Okay.
Okay. Thank you very much. Tara Dykes. Tara Dykes. Caldwell versus Tara Dykes, 24 CR 0036. Are you Tara Dykes?
Yes, sir.
Born in 1990.
Yes, sir.
Last 4 digits of social security number are 4550,
Yes, sir.
different pretrial conference. What do you have, Mr. Stock?
Penalty plea, as far as I know.
Ms. Dykes, a motion has been tendered, said you wish to enter a plea today, is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol?
No.
Is the plea free and voluntarily given?
Yes, sir.
Okay. Are you the person we previously identified as being in 24 CR 0036?
Sir.
Is your judgment impaired today anyway?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
You view the evidence the Commonwealth has against you, you believe you're fully informed about the case.
Sir.
You understand that you do not have to enter guilty plea, that you have certain rights under protecting the United States Constitution. Before I accept the plea, I need to know that you understand those rights. I'm going to go over the rights with you at the end. I'm going to determine, ask you to acknowledge that you understand that, okay? You have a right not to testify against yourself. No one can do the same thing. You have a right to speak out on video. I think it's counsel to your trial. Right, confront across the and all witnesses called to testify against you, right? This evidence, right, to call witnesses to faith. Right to bill this matter to higher court. Lose the right to part of the Commonwealth, prove on the reasonable doubt to guilty of the prosecution. You understand that in the guilty plea, they give up all those rights. Do you understand that? Now, we consider the Commonwealth's recommendation by may apply any penalty allowed in the law. Prior to accepting your recommendation. This is not a diversion, please.
No, Your Honor.
Prior to accepting your recommendation, I'll look at the pre-sentence investigation report, report done on probation and parole. In the event that I want to impose a harsher sentence, I will allow you to withdraw your plea. You understand that? What is the Commonwealth's recommendation?
Upon a plea of guilty to theft by unlawful taking over $1,000.
Now that, yeah, I think you're gonna have to come over here because it's not key.
It's not picking me up.
Okay.
Not sure about it. Thank you. Upon a plea of guilty to theft by unlawful taking over $1,000 and persistent felony offender second degree, the defendant shall receive a sentence of 7 years to serve. The Commonwealth will oppose probation. On a plea of guilty to DUI first, aggravating circumstances, the defendant shall pay a $200 fine. The defendant shall pay fines and court costs at the discretion of the court. It is understood that, that's it. Sorry. That's the end of the plea offer.
Is that what you agreed to?
Yes, sir.
Now, has anyone, including your attorney, offered you any recommendation of benefits or this plea?
No, sir.
You're entering this plea because you committed the acts charged in the indictment. You do so of your own free will. Knowing
Yes,
your
sir.
constitutional rights, explain to still your desire to proceed with a guilty plea and allow the court to fix your punishment. Is that correct?
Yes,
And
sir.
you understand that by entering a plea of guilty on the DUI and on the felonies, any future convictions could be enhanced as far as your range of penalty. Do you understand it? Give me an underlying background. What is this?
It's involving the theft of 2 different automobiles, and Ms. Dykes also has previous felony convictions out of Jefferson County for stealing automobiles.
Okay. Is that your signature on the mo? Let me have the motion. Is that your signature?
Yes, sir, it is.
I'll accept a plea agreement order pre-sentence investigation report to be done with probation and parole. We'll schedule your sentencing on October the 24th. Okay. Thank you very much.
Thank you, Judge.
John Lynn. Commonwealth versus John Lynn. Are you John Lynn?
Yes, sir.
24 CR 0038, Commonwealth Kentucky. Versus John Lynn. Mr. Lynn was born in 1991.
Yes, sir.
4 digit social security number 1238.
4238. Yes, sir.
42 or 12?
4.
We got it wrong on the docket here. 4238. Okay, what does Commonwealth have to say?
Your Honor, we have a motion to revoke his bond based on the fact he cut his ankle monitor, consumed alcohol and marijuana. Mr. Pondexter said they'd stipulate to that, and if they do, then we just need to get a negotiation date, another pretrial.
Okay, negotiation date will be on October the 18th. And the next court appearance is October 24th. Both of those are conditions of bond. He's being held without bond because of the revocation.
Yes, sir.
The attorney will be up to see you real soon, Mr. Lane.
All right, thank you.
Nathan Martin, for purpose of hearing, Nathan Martin. Commonwealth versus Nathan Martin, 24 CR 007. Are you Nathan Martin?
Yes, sir.
You were born 2001.
Yes, sir.
Last four digits of social security number 8057.
Yes, sir.
Hearing today for the purpose of arraignment. Looks like the Office of Public Advocacy represents you.
Yes, Judge.
You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with strangulation in first degree, terroristic threatening third degree, assault in the fourth degree. Counselor, do you acknowledge the identity of your client? Waiting formal reading in the arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Judge.
October the 18th for negotiation day, October the 24th for the next court appearance. I'm signing a reciprocal discovery order of Mr. Martin that will provide you evidence to help prepare your case.
The court would indulge me in reviewing Mr. Martin's bond.
Okay, go ahead.
Judge, the grand jury, I know, returned a strangulation first degree count. We believe the evidence, as it comes, will show that this is not strangulation first. We would ask that the court consider a surety
Well, that's
bond.
what we're here for, isn't it? If you're injury charge and we'll decide that.
It is.
What does the Commonwealth have to say?
What is the bond right now, Your Honor?
25,000.
25,000 cash or twice property.
Well, I don't know what he can make and what conditions are proposed. High risk, just
Why is that? Speak up a bit here.
Time he had been case.
What did he have pending?
Traffic case, power, he's got some.
okay.
We're requesting a surety with an ankle monitor.
We'll have to have a hearing on this, okay? You want to schedule a hearing?
Yes, Judge.
Schedule a hearing on October 24th.
Thank you, Judge.
Dewey McCoy. What?
Well, that was David Cross's case. With accident. Well, when it said it for October, which I've been
Yeah,
saying,
they stood in for Mr. Cross.
That was on another case. But I thought Mr. Cross discussed Gabbard. I may have misunderstood him back here.
We can do that specific.
Oh, okay.
Where's that on the docket?
So, jail policy. Right. Okay.
Gary Gabbard?
We'll just do your day specific. Before Mr. Ross said.
I'm sorry, I thought we got
What? For the 18th?
24th, yes.
The 24th. Dewey McCoy. Are you Dewey McCoy?
I'm Garrett Gabbard.
Pardon?
Garrett Gabbard.
Commonwealth versus Garrett Gabbard, 24 CR 0057. Commonwealth versus Garrett Gabbard. I already had that marked off for some reason.
Here's just me from Crosses.
Judge, Mr. Cross was here earlier on that case and he said that they didn't reach an agreement and you scheduled him for a pretrial and a negotiation in October.
Yeah. Okay. October 18th and the 24th.
Thank you.
Who was the other one that was scheduled for Cross?
Barry Wilson.
Maggie Scott.
We entered a plea in her.
Okay. Dewey McCoy. You are Dewey McCoy?
Yes.
Morning. This is 24 CR 0052, 24 CR 0053. Mr. McCoy, you were born in 1982.
Yes.
Last four digits, social security number 4837. We're on pretrial conference. What's the conference?
Your Honor, that Mr. McCoy has two cases involving multiple defendants, and we're waiting on labs in both cases. We had one lab result come back where there was a little bit of meth, but 6.372 grams came back a non-controlled substance. So they're getting some of the stuff ready to test on that. And then in the other case with Brandon Polson and Matthew Riley and Dewey McCoy, there's methamphetamine and bags that need to be sent to the lab, and the state police said they would send them at the first of the month.
Judge, yeah, I guess at this point in time, we probably need to schedule another pretrial conference. I will say that I will be filing a motion in the first indictment that was issued that the Commonwealth referred to, and discuss that with one of the co-defendants counsel, Mr. Pennington. He was going to be here today, so we were going to
motion to suppress.
Motion to suppress, yes, Judge, based on some of the information received from the initial encounter. And in light of that, some of the drug testing came back regarding the first indictment. I believe it was melatonin that came back. Judge, I would say that some of the other evidence that's going to be sent off to the labs may take some time. And
what's he actually charged with?
Multiple things, if you give me a note, Your Honor. In the first case of 24 CR 53, he's charged with trafficking first offense and PFO, trafficking second offense and PFO, trafficking in marijuana. That occurred on June 13th, 2024, according to the indictment, allegedly. Then in 24 CR 52, he's co-defendant with Oscar Farley and Tamara McCoy. He's charged with criminal abuse first degree, 3 counts, PFO second, wanton endangerment first degree, 3 counts, PFO second, possession of controlled substance first degree, endangerment, welfare of a minor.
We'll just need to have a hearing.
with regard to our suppression motion, yes, Judge.
You're gonna talk about the bond.
I was going to ask for a review bond and see if there was.
Yeah, but we can have here the bond hearing on that same day.
Okay.
I'll know more about the lab.
Yeah, October the 24th. Is there a reason to schedule negotiation and get case bonds in the lab? Lab won't ever come back with
I can't imagine, Judge. I'll have my motion scheduled for the 24th.
Okay, and if the
Both
lab's not
motions.
back, you can still do your bond motion.
Will do, Judge.
Thank you. Tamara McCoy. Commonwealth versus Tamara McCoy. 24 CR 0051, you are Tamara McCoy. Is that correct?
Yes, sir.
You were born in 1990. Last 4 digits, social security number 0591. We're here on a pretrial conference. Now, this is a companion case, is it?
She's companion to Dewey McCoy and Oscar Farley, and she's charged with wanton endangerment, 3 counts, criminal abuse, 3 counts, endangering welfare of a minor, possession of man.
You have a negotiation?
Yes.
Negotiation day on October the 18th, and the next court appearance on October 24th. Have y'all got to have conflict of counsel, or what's the deal?
We represent Ms. McCoy.
Do you?
Yes.
And who represents the other? Mr. Wilkerson represents Dewey.
That's correct. And Mr. Pennington represents Oscar Farley, I believe.
There was a conflict on.
There's a waiver.
Got a waiver, okay. Negotiation day on October the 18th. Next court date on October the 24th, okay?
On Ms. McCoy, Judge, she is about 3.5 months pregnant. Discuss the matter with the Commonwealth. They would leave it up to you. We are requesting an ankle monitor for Ms. McCoy. I don't believe the Commonwealth has an objection if the court is okay with it.
Well,
I don't know. The only thing concerns me, I don't know if pretrial still drug tests or not since she's pregnant. And then,
She'd be willing to do anything the court ordered.
can she go to Russell Springs, get drug tested? Do they test up there? Where y'all drug test us? What's the closest, Russell Springs? Ms. McCoy, how many other children do you have? Speak up.
Three.
Where are they located?
They're with their grandmother.
Is that here in Cumberland County?
Yes.
Okay. Now, where will you stay if you get out of jail on bond?
At 201 Veteran Street.
Who lives there?
That's Daddy's house, my house.
Yeah. Who else would be living there?
No one.
Do you have anybody to transport you for a random drug test into Russell County if we let you out?
Yes.
You'll pay for that drug test.
Yes.
Well, I'm gonna go ahead and let you get signed out on an ROR bond. But I'm gonna put you on, that you're confined to your house, church, work, or doctor, and you're not gonna be working. So let's say church or doctor, and then I want to be subject to a random drug test if they call you to appear there. And I'm gonna tell you, if I have any hint of any drug or anything that might harm your baby, then you'll deliver that baby in jail. You understand what I'm saying?
Yes, sir.
Okay, well, let her out. You got somebody come up and pick you up? Who's gonna come up and pick you up?
Melissa will. Yes.
Okay.
Thank you, Judge.
Don't let me down. Okay?
I won't. Thank
Okay.
you.
Pretrial's gonna coordinate with her on the drug test.
Yes.
Okay.
Larry Minge. Larry Minge.
Hello.
Well, good morning. If it's still morning, I get up. Good afternoon. 12:01. So, Commonwealth versus Larry Minge, 24 CR 0034. You are Larry Minge,
Yes, sir.
born in 1963.
Yes, sir.
4-digit social security number 3673. Is that correct?
Yes.
What is- I'm gonna say this.
We have a felony plea, Your Honor.
Mr. Minge, your motion's been tendered, says you wish to enter a plea today. Is that correct? The motion has been entered, Mr. Minge. It says you wish to enter a plea today. Is that correct?
Yes, sir.
Hello, Mr.
Yes,
Are
sir.
you currently influenced with drugs or alcohol?
Oh, sir.
Pretty freely, voluntarily given.
Yes.
Are you the same person we just identified in 24 CR 0034?
Yes, sir, I am.
Judgment impaired today. And
No, sir.
you discuss this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
You need the evidence the Commonwealth has against you, whether you're fully informed about your case.
Yes, sir.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky of the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. Now I'm gonna go down through the rights, and at the end, I'm gonna ask you to understand them, okay? You have a right not to testify against yourself. No one can make you say that. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor. Right to fill this matter to higher court if you lose your right court. Right to impart the Commonwealth proves on a reasonable doubt that you're guilty charged against you. Understand that by entering plea of guilty today, you give up those rights. You understand that?
Sure.
I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to sentencing you, I will ask for pre-sentence investigation report to be done by probation and parole. In the event that I decide to give you a harsher punishment, I will allow you to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Ms. Gordon Anderson, what is the Commonwealth's recommendation? You come over here.
Okay.
It's okay.
Upon a plea of guilty to trafficking in a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 6 years to serve. The Commonwealth will oppose probation and shock probation. upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08, or while under the influence of alcohol or other substances aggravating circumstances, the defendant shall receive a sentence of 7 days and a fine for $350. The defendant agrees to forfeit $804 that was seized during the incident, 85% to the Cumberland County Sheriff's Department and 15% to the Commonwealth Attorney's Office asset forfeiture. 2006 Lincoln Town Car, VIN number 1LN HM82V66Y634594, seized during said incident shall be released once tow bill and reasonable storage fee have been paid in full at the Cumberland County Sheriff's Department. The defendant shall pay court costs in the discretion of the court. The defendant shall obtain gainful employment after 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all court costs are paid in full and until further request and probation and pro.
Is this probated sentence?
No, so that probably should not have, it is. The prison sentence, so that probation probably shouldn't have been in there. That sentence, last sentence.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment?
Yes.
You doing so of your own free will because you are guilty?
Yes, sir.
Constitutional rights explain to you still your desire to give up those rights and allow the court to fix your punishment within the range permitted by law. Is that correct?
Yes, sir.
Read the document, Mr. Bailiff. Is that your signature, sir?
Yes, sir.
I'll accept the plea. You can give that over to her.
Yes, sir.
I'll accept the plea. And you understand that any further guilty pleas on this or the DUI, either one could enhance the range of penalties. You understand that?
Yes, sir.
I accept the agreement. Order pre-sentence investigation report. Your sentencing will be on October the 24th.
Thank you, Judge.
Thank you. Yes, sir. Thank you.
Caldwell versus Raymond Miracle, 24 CR 0045. Are you Raymond Miracle?
Yes, sir.
Were you born in 1968? You born in 1968, Mr. Miracle?
Yes, sir.
4-digit social security number 2538, is that correct?
Yes, sir.
You're on 24 CR 0045. What do we have, Mr. Stock?
Well, we had to pass his negotiation days in, but we passed, wasn't able to attend last negotiation day, but I guess we need another one for October. Is that correct?
Yes, 18.
What's he charged with?
Trafficking.
No, I believe it's a convicted felon in possession
Possession of a
firearm.
firearm. That's
I think that's. Oh, thing prison error.
No, you're right.
There might be a PFL attached.
And he's got cases pending in other counties. I don't know if he's in state prison.
He's not, Your Honor, and that's kind of what's holding us up from resolving this one is the older cases out of Hardin County, this directly impacts those. So we are set to handle those early October. So we should have more of an idea about that negotiation.
Let's say a negotiation date for October 18th and the next court appearance on October 24th. But you remember what they're going to try to do is take care of your cases up north, and then once they resolve those, you can come back and try to see how they just fit it. Okay?
Your Honor, I wanted to briefly address bond in this matter.
You need to schedule a bond hearing.
Okay, formal bond hearing.
Yeah.
And
That's what the day was. That's what the day was.
today's a pretrial, Raymond, but we'll get a formal bond hearing scheduled. Is October 24th the only pretrial conference date you have in October, Your Honor?
Yes.
What is your November date?
Well, you can set one in October. If he's gonna be here anyway for the pretrial, if you don't have a resolution by it, then you can schedule a man's entitled to a bond. Unless a bond hearing anyway. Okay?
Okay.
Okay, thank you.
All right, thank you, Judge. That's all I have. If I can be
Okay,
excused.
absolutely. Alvin Mullins. F1 versus Alvin Mullins, 24 CR 0068. Are you Alvin Mullins?
Yes, sir.
You born in 1967?
Yes, sir.
Last 4 digits social security number 7631.
Yes, sir.
You're here for the purpose of arraignment. You have the right to remain silent. Did this go to district court?
Uh,
You have a public defender's office to represent you. I'll continue that appointment.
yeah, but I just want to change my plea, sir.
Wait a second. I've got to arraign you first, okay? The grand jury of Cumberland County has returned an indictment charging possession of controlled substance, first degree, second offense, and public intoxication. You acknowledge your receipt of the indictment, the identity of your client, waive formal reading and arraignment, enter plea of not guilty temporarily anyway. Now, have you talked to this man? Have y'all talked to this?
Yeah, I talked.
Sure, Mr. Manager.
Mr. Pennington has talked to him and he says now that he wishes to enter to change his plea.
We don't have any plea paperwork, Judge. Is there an agreement?
No, he's just been around.
What's he charged?
Possession. I told Mr. Roby we have the rocket docket next month. Talk about it, Mr. Roby, we haven't started doing that yet.
So y'all haven't looked to see what's his background. You know, let me see what's. He's what now? What's the previous convictions?
He's got quite a bit of criminal conviction.
Okay, well, y'all just have a negotiation on the 18th and bring him back here on the 24th. We'll be able to resolve it all on that day, Mr. Jones, okay? You understand?
Yes, sir.
Your lawyer's gonna be up to see you. They'll bring you down for negotiation on October the 18th, and then we'll have you here in court on October 24th. If you wish to enter a plea on that day, we'll have the paperwork ready, okay?
Okay.
Okay, thank you.
Thank you, Judge.
Yeah, Raymond Oliver.
Yeah.
Caldwell versus Raymond Oliver. 22 CR 00108. You Raymond Oliver,
Yes, sir.
born in 1969.
Yes, sir.
That's 4 digits, social security 1975. You're here today for
Yes, sir.
sentence. Got an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Substantially correct.
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor, I did want to state for the record, though, this case, Your Honor noted, this is a 22 CR case. This case arose before the House Bill 5 had passed on July 15th. So we would like just to state for the record, because we don't know how this is all going to be interpreted as far as sentencing is concerned for parole, that because his plea or because his case arose prior to the law change and the charges arose prior to
There's
that.
no reason for you to tell me that.
Well, Your Honor, I'm just protecting the record that his
I
sentence
don't
should
know.
apply under the old law, and the new, any new House Bill 5 effect should not affect it. We're just preserving the record because we don't know how DOC is going to interpret all of these things,
Were
so.
you asking me to make a ruling on it?
No, Your Honor, I'm just saying,
Because I'm not prepared.
no, Your Honor, just stating that on the
House Bill
record.
what?
House Bill 5.
Well, you know, there's a House Bill 5 every year. And
This one is particularly, we don't like it, but
I assumed that it was not good in your side, you know.
yes, Your Honor. So we just
What
want to,
session of General Assembly 2024?
yes, Your Honor.
The Commonwealth attorneys will.
Okay. But on a plea of guilty to first degree rape, 10 counts, defendant shall receive a sentence of 15 years on each count to run concurrently for 15 years. On plea of guilty of incest over age of 12, 10 counts, he should receive 15 years to run concurrently, or a total of 15 years. Upon plea of guilty of sodomy over the age of 12 years, 10 counts, the defendant shall receive 15 years on each count to run, total of 15 years. Upon plea of guilty of sexual abuse, first degree, victim over 12, the defendant shall receive a sentence of 5 years. Upon plea of guilty of sodomy, second degree, victim over 12, it shall receive a sentence of 10 years to 15. 15-year sentences on rape 1, incest, sodomy are to run concurrently, the total 15 years. 5-year sentence on first degree sexual sentence of sexual first degree, and 10-year sentence of sodomy second degree run consecutively, total 15 years. The 2 15-year sentences are to run consecutively for 30 years to serve. The Commonwealth will impose probation, shock probation, and any court cost or weight.
Thank you, Your Honor.
Thank you. Matthew Riley. Matthew Riley. Versus Matthew Riley. 24 CR 008, 24 CR 0049. Are you Matthew Riley?
Yes, sir, I am.
Born in 1968.
Yes, sir.
The last 4 digits, social security number 8553.
Yes, sir.
Pre-trial conference, what do y'all have going on here?
Your Honor, in Mr. Riley's second case, he is a co-defendant, with Mr. Hoy
And Mr. Post.
and Mr. Polston, Your Honor. We are still, that is the case that the KSB informed Mr. Stockton that they would not be able to take the lab or the evidence to the lab until the 1st of October. Is that
That's
correct?
correct, yeah.
Okay. So Mr.
So you want to put this in November?
That'd be fine, Your Honor.
What's the negotiation date in November?
The 8th, I believe.
November the 8th, and the next court day, November 21st.
And Your Honor, just so for Mr. Riley's benefit, Mr. Stockton and I have been discussing possible bond resolutions, and if we could reach one, we'll do so by agreed order.
They're gonna try to reach a resolution to get you a bond, Matt, okay? Get you a bond.
That's fine. I appreciate it.
They'll work it out, whatever they agree to. I don't think he's a flight risk. So I don't think they couldn't run you out of Rally Hole if they wanted to down there. So they'll be getting back with you, and I'll sign a bond resolution, okay?
Thank you.
Thank you, sir. Appreciate it.
Zachary Smith. Commonwealth versus Zachary Smith. Sentencing. Commonwealth versus Zachary Smith, 24 CR 0048. Are you Zachary Smith? Were you born in 1995?
Yes, sir.
4 digits, social security number 8147.
Yes, sir.
You're here for sentencing today.
Yes, sir.
Get an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Substantially correct.
Yes, sir.
Any reason why this gentleman should not be sentenced?
No reason he should not be sentenced. There was one issue with his medical conditions. We just wanted to bring it up.
Okay.
They have him down with an illness that looks like Lecula, Lecula. That's incorrect. He has emphysema.
Emphysema. Will you make note? Probation, parole, make note to change that. Okay.
That's all.
On plea of guilty of fleeing and evading police officer's first degree motor vehicle, he shall receive a sentence of 5 years. Plea of guilty of possession of firearm with conviction felony, receive 2.5 years. The 5 years sentence in 2.5 years shall run consecutively for a total of 7.5 years. Commonwealth will oppose probation and parole. Hey, I'll sign the order. Thank you very much. Cody Stinson is next. I'm gonna waive court costs since he's serving that time. Cody Stinson. 24 CR 0044. Are you Cody Stinson?
Yes, Your Honor.
You're here on 24 CR 0044. Were you born in 2004?
Yes, Your Honor.
What is your social security number 8596? You're here at pre-trial conference. Let's come on ahead and say.
As we were discussing, he has a new felony case that's also involving sexual abuse, so we'll probably go to grand jury next month. And we haven't got the CAC interviews. That's the reason it didn't go this month, but it should go next month.
Okay, well, let's schedule him for negotiation day on October the 18th. And the next court date, October 24th, we can receive that information if you feel you're gonna, if you reach some agreement on it.
That'd be fine.
If not, you can postpone the negotiation date, and just have him appear here on the 24th for return to that, okay?
Thank you, Judge.
Okay.
Amber, make sure you go ahead and contact.
Mr. Stinson, they've got another case they might be bringing up, and they're gonna try to roll it all in together, they'll get in contact, you come down.
Have I been indicted for it or am I charged with it?
They're gonna present it to the grand jury next time, and what they're gonna do is, or try to save you some time, so you have to wait 2 more months. They're gonna let you inform you of that on your negotiation, even though you haven't been indicted for it yet. They're gonna inform you of it, you can make a decision on what you're gonna do with it, okay?
Correct. I thought I was informed I thought I was here for a bond hearing today.
No, you weren't here.
We're gonna file for a bond hearing on the 24th. We spoke with his family.
He said that they're gonna file for a bond hearing on the 24th also, if they can't have a resolution, okay? Thank you. Charles Thurman. Charles Thurman.
Yes, sir.
Cromwell versus Charles Thurman. 23 CR 008, 23 CR 009, 23 CR 0011 and 12. Are you Charles Thurman?
Yes, sir.
Good afternoon, Charles. You know, we have a motion for petition for involuntary hospitalization. What's the story?
Have we got a GAL appointment for him? I'm ready to schedule a hearing if we need to. But I just want to make sure there's a guardian ad litem, and I'll have several witnesses. I'll have the officers in both cases, plus the doctor from KCPC.
I pray we ain't had a great good life. All those, everybody, everything. Pray we ain't had a very good life. Yes, sir.
I'll encourage you to go ahead and appoint Holly. We're gonna appoint you someone to look out for your interests. You got a public defender here. So you're gonna have 2 people looking out for your interests here, Charles. You're gonna make sure you're taken care of, okay?
Okay.
Okay, thank you very much. They'll be up to see you soon.
I'll leave.
You're good.
Hey, thank y'all. Have a good day.
Thank you very much. Robert Young.
You schedule that for October 24th, the hearing, at 9. Oh.
You need to get that to Ms. Gray. Robert Young, are you Robert Young?
Sir.
You born in 1978?
Sir.
Last 4 digits, social security number 3613.
Yes, sir.
We're here on 22 CR 0025 and 24 CR 0020. Okay. What does the Commonwealth have to say on the probation revocations?
Your Honor, Mr. Young has a 5-year sentence. He was referred to specialty court. He missed a drug test, forced a note from the hospital, missed a mandatory function. He missed a drug test and forced a note, said he was in the hospital. He missed a mandatory function for specialty court, failed a drug test on August 8th. And this occurred after he basically absconded from drug court, came into the drug court team and said that he wanted to do drug court, and we let him back in. So that's what's happened in this case.
What do you have to say about it?
Judge, it's hard to disagree with the allegations. We would ask that the court consider a graduated sanction and another shot at drug court.
Go over that, what happened again.
Let's start out. He was referred to drug court. He met with Mr. Murphy, I believe, one time. Then he never showed up for anything. He absconded, and they had to put him in jail. He came in and met with the drug court team and said, I want to do drug court and I want to do this program. After that happened, he missed a drug test, basically forced a note and said he was in the hospital. missed a mandatory function, and then failed a drug test for methamphetamine and methamphetamine. He was terminated. So basically, he got 2 bites at the apple, and he got terminated anyway.
What's the sentence?
5 years.
On what?
Legal point endangerment. Let's see. It is 5 years on one endangerment, first degree, and 2 years on possession of controlled substance, first degree, and there are 2 different cases. 22 is 25 and 24 20.
I'm gonna go ahead and revoke it. You know, we take drug court very seriously, give an opportunity to go into drug court, he completely expunged his record after he finished it. And he absconded, and it's kind of unheard of.
With Judge
To
Costello.
allow somebody a second chance at drug court here when they absconded, and he was allowed that and then ignored it again. So there's absolutely nothing I can do, Commissioner Young. And I hope he turns his life around and gets treatment in prison for his addiction problem. Adair County, y'all have anybody else up there?
No, that's it.
Thank you for your cooperation very much. Y'all are excused. Mr.
you.
Commonwealth Attorney,
No, Your Honor.
you sure?
No.
Go off the record.
Judge, we have show cause.
Okay, let's go to show cause docket.
May I be excused, Judge?
Absolutely. The show cause docket. Okay, show cause docket, it was scheduled for 11. Howell versus John Anderson. You what?
He's been paying since 2023, but he's not been paying since August.
How much is he owed?
$230.
Issue a bench warrant for him, he can, hurt himself by paying $130. Sandra Faye Dyer. Ms. Dyer, you owe $145. What's the deal here?
Going down to rehab for like 2 months.
You what?
I've been in rehab. I got out like June the 28th. And I've been working odd jobs and helping my sister babysit, clean the house so I can get a job. Have
Well, you
application.
go ahead and pay. How much can you pay today?
I won't be getting paid till tomorrow.
What do you get paid tomorrow? How much?
Probably like 100.
Okay, I want you to pay $20 tomorrow, okay?
Tomorrow.
And you pay $20 a month, you pay this $145. That's really need that. I don't want, you're out trying to work.
Yeah, I'm trying.
Okay, we pay $20, but close the business tomorrow, they're gonna be there for the rest of the month, okay? Okay,
Thank you.
good luck. Anthony Garrett. You order to pay $100 a month, Mr. Garrett, what's the story?
Yes, sir. We got behind at work and,
Where do you work at?
Charlotte contracting,
Where?
Charlotte contracting. We, set up a prefab cabin.
Well, is this restitution? What is it? Who's it to? Okay, well, you pay $100, close the business tomorrow, we'll report to the Dare County Sheriff.
All right.
Okay, you pay $100 a month, that's what you're supposed to pay.
I just fell behind it.
I know, that's the reason I'm not putting you in jail, right? I won't work with you, man.
Thank you.
Okay, have it paid by end of work, end of tomorrow, and then $100 a month, okay?
Thank you.
Thank you. Carolina Hood.
Okay, August 30th.
Okay, well, have her, is this restitution here? What's she supposed to pay, $25? Have her pay $50 by the close of business tomorrow, issue a bench warrant for her. And put her back on the docket next month at $50. And the last one is Paulette Wilson.
She's calling this $50.
$50 payment. Okay, that's it. Does that conclude the show cause docket? Okay, thank you very much. She's good?
No.
Well, the record.
That's.
And lady get right, they big trip. I don't know. She don't listen to them, she calls somewhere. Like,
Okay, you got an order?
I do. You want one by one or all at once? I've got several today.
Just doing one at a time.
Okay.
Shelton versus Shelton.
Review, January 23rd, please.
Casey, Evers versus Jones.
Judge, we're asking Mr. Jones's case to be reviewed December the 19th.
Okay. Sad. Long versus Long.
23rd of January, please, for review.
Norris versus Norris.
23rd of January for review, please.
Cooper versus Cooper.
23rd of January, please.
Hill versus Haywood.
Judge, this is our motion for contempt. There is an outstanding arrearage. I did not see Haywood in the courtroom today. He has a current arrearage of $4,154.76. That's excluding his current month's payment of $298.50. We're asking that the court hold him in contempt and allow him to purge himself of contempt by paying $1,000 on or before October the 23rd.
Okay. That's right. Carver versus Carver.
I do think parties of the council may be here on this one. The court wants to, it is noticed for a motion for contempt. Similar to the last one, was asking for a contempt order.
Wait a second.
Sure.
Is Mr. Carver here?
I'm sitting in for Chris Davenport. I represent Miss Carver, Judge.
Yeah.
Okay.
She's standing.
Yeah, I know. I just want to introduce myself again.
Who represents him?
What's his last name?
Elmer George representing him in this or criminal, the criminal?
Criminal.
I'm not sure if he, what all he represents.
Who did you send those to?
We notice in this case, I believe our notice actually goes to Mr. Carver. Let me check and see.
And do y'all have
Yes.
do y'all have a motion later in the civil docket too, or is this the only thing?
This is the only thing.
And Judge, just so the court's aware, like I said, it was noticed for a motion for contempt. He had an arrearage of $5,773.24. Yesterday afternoon, he paid that full, brought the arrearage current. So there is no current arrearage. It's my understanding he has not yet paid his September payment, but his arrearage was satisfied yesterday. I have proof of that.
That's good enough for me. We'll just let that go and
I would ask that it just be reviewed just to keep it moving the payments.
put him on for October the 24th for the
Okay. I'll tender an order.
Okay, thank you. Howell versus Nicholas Raisin, is that correct?
Yes, Judge. His is also our motion for contempt. We were asking he be allowed to purge himself of contempt by paying $500. He paid this week $200. So I'm just going to make this change if it's okay that he can purge himself of contempt by paying $300. Make the change initially.
Child support document.
That's all I have, Judge, on the child support documents.
Make sure she knows that now. Okay, Mid-South Capital Partners versus Nathan Nedry.
Afternoon, Your Honor. Jeff Patterson from Mid-South Capital Partners. That's our motion for judgment order of sale.
We have been following. You just charged them the 2,000 for attorney's fees, is that right?
Yes, Your Honor, we always cap ours.
It'll be fine, I'll sign it.
I'm sorry?
I'll sign your order.
Great, thank you, Your Honor.
Sure, I signed that document there. The $200, Chairman, would have been taken. Okay, you paid your, if he's gone there, I guess.
I'm still here, Your Honor.
Paid the 200 whatever dollars for your cell fee and
Yes, I believe we have.
she's checking the file. Court gets on when you said it hadn't been paid. I don't see a receipt. Would you double check?
We'll double check, Your Honor. We usually do it with when we file it, but I'll make sure, and if not, we'll get it tendered.
Some receipts usually stapled on the inside, so if you'll double check that, I appreciate it. And if you're making timely payment, then we'll proceed, but until the payment's made, we can't proceed, okay?
I understand.
You what?
It's still viewed according to the computer.
It's what?
It's still viewed. They have not
Okay,
paid.
yeah, computer doesn't indicate you paid it, okay?
Okay. All right.
Roger Bobby versus the state of Leslie Thrasher, deceased.
Judge, this is Mr. Jean's motion. We discussed.
Y'all get behind the podium so I can hear you.
Go ahead.
Yes, hi, Your Honor. Robert Jenkins for the estate of Leslie Thrasher. It's our motion to dismiss. Mr. Hurt and I have talked about this a little bit before the.
Give me some background on this. I read the motion, but give me once upon a time.
This was a car accident case involving a motorcycle. It's a personal injury case. And it involves an estate. The estate was closed and reopened in order to effectuate service. Service was never effectuated. And so what I am asking the court is to hold the motion in abeyance for 30 days. I think we're going to be able to bring this one to a close to get it. I think both of us are desirous of that.
Okay, let's schedule it for October. You want to do it November 21st or you want to do it for October 24th?
Either is fine with me, Judge.
Well, let's do it for November 21st and then I'll sign any kind of agreed order that you don't have to make another appearance about, okay?
Okay, very good.
Thank y'all. Have a safe trip. Good seeing you.
Thank you. Good to see you.
John David Dishran versus Ricky Spears. David Cross and Ted Lavitt.
I'm here for
Now,
that.
Mr. Cross.
I'm his assistant. He is in a trial in Pulaski County. He wanted me to let you all know he doesn't have any objection to a trial being set.
Okay, he already told me, but I don't see Mr. Lavitt here. So you just stay on the line and listen. And if Mr. Lavitt shows up, we'll talk. But I'm not really prepared to sit. If Mr. Lavitt shows up, we'll set a trial date if Mr. Lavitt is ready. If Mr. Lavitt isn't ready, then we'll have to set it again and let both sides tell me why they aren't ready. Kyco Land Holdings LLC versus John Russell Key and other people. Well, y'all been paid off on this?
We've been paid off and we moved to dismiss. We wanted to give the other entities an option of taking over as plaintiff if they so chose.
Did you serve all of them and give them that option?
Yes.
You see, we see. I didn't notice that there were other defendants that hadn't been taken care of.
They may have, I just don't know. There was Rex tax liens, tax break.
Cumberland County file, interesting. That looks okay. Yeah, I want the clerk's office to note that that these other defendants have not been dismissed. The case hasn't been dismissed as far as other defendants. All I'm saying. Okay.
Thank you, Your Honor.
Yeah. Specialized Loan Servicing LLC versus Bobby Garment and others.
You follow, you had something, you're good order of sale, they got paid off on that, and they have done over to vacate judgment business case. Scheduled for the.
Order to vacate. Has the sale already been scheduled or anything? Okay. Casey Ray Scott versus Summer Gay Scott. It's a motion for decree and it's one of Ted Lavitt's cases. Are you Summer Gay Scott? Does Ted Lavitt represent you or? No, he represents.
He represents.
Mr. Scott.
Yeah.
Did you have an attorney in this case?
No, sir.
Did y'all make any property settlement or anything? Any property settlement?
That's what we're supposed to be settling, yes.
Do what?
That's what we're supposed to be settling, yes. Like our home, just.
There's no $7 big position in the petition. And. Opinion, that's all.
Do you have a lawyer?
Do not.
You need to get a lawyer. You know, there's a motion for parties do not reach the property settlement agreement, division of property and debts, and all issues of corporate desires to solve the marriage. Proof having been taken by deposition, the court will consider the same. The record be fully advised. Court adopts the allegation with respect to jurisdictional, includes that matter of law that they're entitled to live solve. Judge. So we're going ahead and do the divorce, and they want me to decide you want me to decide based upon the depositions. Did you give your deposition? You take a sworn statement from you?
No, no, sir.
No, I'm not you don't want the divorce until you get the property settlement, do you?
No, sir.
Okay, well, you need to get a lawyer. Okay, because I'm not gonna do this decree and then you not even give a deposition or anything, so. You'll be back here on October 24th with a lawyer, okay? Or have the lawyer file some kind of motion and stuff, okay?
Yes, sir.
Okay, please. Mitchell Page versus Tammy Lynn Page. Page versus Page. Hello, Judge. Hello, how are you? Hello to the pages. Okay, now this is a motion for the decree to be signed. Has there been a property settlement done in this case?
Judge, until this time, we filed one, yes, with you, but until this time, we'd had no response from Miss Page. So we filed the default, motion for default judgment. So we had served her and had no time.
Have you looked at the property settlement agreement that's been proposed to you?
Yeah, he's supposed to get everything. And I have tried to get a lawyer. I went to 4 different ones. They've done work for him or his family and won't take it, so. Mr. Cross has given me some names. I went and talked to David. He gave me a couple of names to check into. But what they're wanting is,
What, do you have any, are you willing to sit down and talk to him today about what you want? You have in mind what you want? How long y'all been married?
be 8 years, February
Yeah.
26th.
Would you be willing to talk to her?
Judge, of course, we understand, that she's here now. Just want to make sure that we're under the impression she didn't file a response within the 20 days. I
I
understand.
know she didn't
I understand.
respond.
But I did call him.
Well, that's not good enough. Call it, okay? It's not good enough.
But he is
Wait
supposed
just
to
a second.
return.
No, there's no reason to say this. We want to make sure we do it clean and that sort of thing. But you calling somebody or talking to somebody is not good enough, okay? You've got to sit down and negotiate, and maybe if you have some idea of what you want, what you think would be fair, you might tell them that today. And you might be able to reach an agreement, or I'll give you a month, to come back here, and if you don't have it taken, you can't, it's gotta be signed, it's gotta get over with, okay?
I would, excuse me, can I?
Yeah, go ahead.
I would rather for you to give me some time so I can get a lawyer, because actually I don't even know what we have. And I mean, like,
Well,
really,
if you've just been married 8 years, I would assume that a bunch of things that he owned before you were married.
no, well, he sold
Well, I
all
don't
that.
want you to answer this.
Yeah.
Okay, I'm just making a presumption,
Yeah.
saying. And if he sold things and reinvested money that he had, he could trace that if he
Mhm.
sold things he had before y'all were married.
Yeah.
So you need to get a lawyer.
Yes,
Okay, I'll give you 15 days to have a lawyer to enter an appearance, enter in negotiation with him, and then y'all be back here on October the 24th. But now, if you don't do this,
okay.
I'm gonna have to sign the judgment. You understand what I'm saying?
What do you do?
You understand what I'm saying?
Yes, yes.
Okay.
What do you do if you can't find a lawyer? Can you
There
get
are
one?
lawyers under every stump around here. You can find lawyers.
Yeah, but
You just need to- well, look, there are all kinds of lawyers in Glasgow. There are all kinds of
Exactly.
lawyers in,
I talked to 3
Medicare County.
lawyers in
Well,
Glasgow.
okay, Medicare County. There are a few lawyers scattered around here, you just have to find a lawyer. I mean, everybody finds a lawyer. I will tell you what, you're the first person I've ever had said they couldn't find a lawyer because there's lawyers everywhere.
You can find them, but whether they'll help you or not.
Well, in Monroe County, they won't, because.
Well, I didn't have no good luck with Barron either.
Well, I mean, Monroe and Barron's the same county as far as
Yeah.
lawyers are concerned. They're all right there together. You got Midcap County, you got Dare County, you got lawyers around, you got 2 lawyers here on the square there. Poindexter can do something, or Pershing can do something. We got other lawyers that do domestic work. We got, so you can go downstairs. You have a lawyer's list downstairs, local lawyers.
Yes.
We've got to stop at the clerk's office downstairs and get a list of local lawyers, okay?
Judge, one thing I would like to make sure and put a motion on the record then if we're gonna keep with this. My client is currently living on his houseboat, and she's in the marital residence, which was premarital. I just would like to put on the record that we would like for him to be able to have exclusive use of the premarital residence. If this does keep getting pushed out,
Yeah,
so.
where are you gonna, when you move out, where are you gonna move?
I'll just have to rent a place.
Well, I'll give you some time to do that. I'll give you a couple of weeks, to find a place, okay?
Now, the houseboat, if he gets to use a house, why can't I go to the houseboat?
Well, here's the thing, when did you buy the house?
Well,
2 years.
Huh?
2 years ago.
And a pontoon.
Well, I don't wanna get into what pontoon and rifle and skis and stuff. Do you have any problem with her living in a houseboat while you go back to the house?
Yes, I do, Judge.
Yeah, well, why don't you just rent a place? Okay, I'll give you a couple weeks to rent a place, and then the issue is, what does she get to take out when she leaves? That's always.
I understand.
So step back and talk to your attorney there. So,
No, nothing, Judge. You're good. He's good.
good about what?
There's nothing he has to
Well,
say
when
to the
she-
court.
What, yeah, but when she moves out, what's she gonna take with her? If y'all don't have to sit down and, I mean, at some juncture, y'all are gonna have to sit down and talk about what you consider to be yours and what he considers to be his and what he's gonna let. I just don't really think there's gonna be that much to decide with the length of your marriage and that sort of stuff. So let's wait. If you're gonna get a place to live, you gonna get a furnished apartment, or what are you gonna do if you don't have any furniture to take? Do you have any furniture that you brought with you?
No, but I got furniture that was bought after we was married.
Well, you didn't bring that with you.
Yeah, but that ain't no big deal. I got places to go. I
Okay,
mean,
well,
I ain't
it's no
worried
big
about
deal
no
with me. I just
stick
didn't
of
want to
furniture.
put you out without anything, out of bed or anything.
Yeah.
So you just leave everything that's in the house there. You don't remove anything and you don't remove anything from the house. You be out of the house in 2 weeks, have a lawyer in 2 weeks, start negotiation, and we'll come back here on the 24th, and you need to file an answer before the 24th.
Okay.
Okay, thank you very much.
Thank you, Judge. That's all my business.
24th here.
That's where y'all filed it at here.
Okay.
Cumberland County. Okay,
Thank you, Judge.
okay, thank you very much. Should
Thank
anything
you.
else come before the court? Not, we're.
Till 2:00.
Is it-
Confidential matter.
1 o'clock as well, Judge, on the 24th.
Yes.
Okay, sorry, Judge. I just want to make sure. Thank you, sir.
At what time did they say?
1 o'clock. Here's my authority.
Okay, thank you.
Yeah.
I got.
Safety.
How many did you send out? Anybody have excuses?
One just. Feels like they're just totally figure all the other times, but just forgot. I haven't talked to the other cities.
Yeah, who hasn't been served?
Jessica Arterburn, there was not return service on her. I haven't heard from them.
Thank you all.
Scott Doherty, he lives on Rush Road. He says that he runs that place that does sea-doo and pontoon rentals out on the harbor. And this is his busiest time of year. I didn't excuse him from jury trial.
You'd be served for today.
No return on it. Philip Fletcher was served.
I'm just wondering who wasn't served.
Correct. Bonita Humphrey was not served. He put a note on that one that just said she was out of town when he went to serve for the paper. Joseph Humphrey has not been served. Donna Jerusalem has moved to Florida. Monica McLeod.
You're all there.
Monica McLeod has not been served. She lives on Smithgrove Road at the very beginning. She said, well, I just got married and I don't have a driver's license and we're gonna be on our honeymoon during orientation. She's never got since. She was never excused. Except for orientation because she's on her honeymoon. That was served. Chase Stevens on Ashlock Road has not been served. Greg Wells, the newspaper guy, has been served. Michael Winfrey, Bakerton Ferry Road has not been served.
Wonder why they haven't been served. These people haven't been served. Can you get a list of people haven't been served.
First thing, I was listening to her go through the list, and I went to all those houses.
Yeah.
And I went during the daytime, sure about home during the daytime.
They just walk out with that, right?
Y'all went there, every one of them.
Did you leave paper on the door there?
No, I mean, I thought it was something I had personally served.
Keaton just gave to Randy to serve one day when, what Keaton was doing, but he asked Randy to serve.
Well, we need to make an effort to serve these other people. And the ones that show up today at 2, I'll handle these.
Okay, so you want me to make these other 6 or 7 for October date?
Yeah, the
Okay.
ones that haven't been served, we'll make October, clean them up. Coleman, you wanna come back for a second?
Get 2 minutes.
Are these, somebody brought me, sorry.
Did you have all these for me?
Thank you, I need to see.
There's 2 or 6 corrections you're not getting.
I'm sorry, I'm saying.
So he'll be back in the gym. Yeah. Hold on, mate.
Yeah.